Your Honor, Jillian Engen for plaintiff.
Good morning. Are they here? Tyrone Moore. They are not here. If you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,895.07. Court costs are $172 for a total of $2,067.07. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days. Evergreen Apartments versus Kabwanga. Is it Munganga? And
Jillian Engen for plaintiff.
And Norbertine Kawanga and Deborah Kabwanga. There being no response, you may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $1,648.24. Court costs are $256 for a total of $1,904.24. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Yes. Could you give me the total number again, please?
Yes, $1,904.24.
Thank you. Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days. Evergreen Apartments versus Christopher Hesterly.
Jillian Engen for plaintiff.
All right, Mr. Hesterly.
How are you doing, sir?
I'm doing well. Thank you. All right, what is plaintiff's claim?
I have a balance including court costs of $2,894.53.
All right. And Mr. Hesterly, how are you intending on getting that paid?
Yep. So I applied for the Michigan. I work for University of Michigan Hospital, and I applied for the employee hardship program. And so right now they're going through the process of trying to help me out with $1,500. I've been off of work for like 3 weeks because I had plantar fasciitis and I think it's called ligament tendonitis. I couldn't walk for 3 weeks, so pretty much my overtime checks or whatnot was kind of low. But I'm back at work this week, so my check I was supposed to get paid today, so my check should be $1,200. And I was supposed to get, I think, like $300 or $400 from my dad to help me out. So I'm trying to see, about the employee hardship program, if they can help me out. To see if,
so that's a U of M hardship program, right?
Yep.
Okay. So how much? Well, you're entitled to a week adjournment. The issue is going to be that all of a sudden your July rent's going to click in. How much is your July rent? Your monthly rent?
It's $1,123 or $29.
Okay, so a little over $1,100.
Right, and my next check is cover that as well. But I know it's a timely situation right now.
No, I got you. I hear you. I am having a docket on the 3rd.
No, you're not.
I am not. Yay! I get a day off. I'll take it. All right. Well, sir, I'm going to adjourn you out 2 weeks to July 10th, 2026 at 1 p.m. That's an in-person proceeding if you're not paid in full, okay?
Okay.
And between now and how much do you think you can get paid on this?
Yep, like I said, I think my check is going to be like $1,200, so probably around, that $1,000 for sure, and then I have to wait to see about the
okay, so here's what I'm going to want. So you're going to pay $1,000. You can get that done by Monday?
Yep, I should be able to.
All right. So pay $1,000 by the 29th. All right. And then you'll get news on that employee assistance program and everything like that, and then we'll see where we are, okay?
Okay.
All right. Thank you. Have a good holiday.
Yeah, thank you.
Evergreen Apartments versus Chanda Richardson.
Jillian Engen for plaintiff.
She's here. Oh, now you're sideways, Miss Richardson. That's okay. I mean, I can turn my head, but then I don't know. All right. You need to unmute. I think that's what she was trying to do. All right. While you do that, you're still muted, but well, yeah, while she does that, what is plaintiff's claim?
I have a balance including court costs of $547.95.
$547.97. All right, Miss Richardson, can you unmute for me?
Okay, hello.
Hello, there you are. All right.
Hello.
It's
I'm sorry, I'm not good with phones.
$547.97. No, you're good. Don't worry about it. How are you intending on getting that paid?
Okay, I'm moving out on the 28th anyway. My lease is up on June 28th. So, but they told me that once I move everything out and turn the keys and stuff in, they're gonna put me on a payment plan.
Gotcha. So you're moving by the end of this
Sunday
month.
Yes, sir.
All right. So what I'll do is, let me just mark the file that you're moving.
Mm-hmm.
And then I'll adjourn this out to the 10th.
Okay.
2026. What time? 1 p.m. That's an in-person proceeding, but if you're moved out and everything, this is a possession-only case. So if you're moved out and have turned in your keys, I don't need you to come down to the courthouse.
Okay. They said they were going to do a payment option with me as well.
Pardon?
They said they were going to do a payment option with me as well.
Yeah, they'll arrange a payment plan. That'll be outside of the court proceeding. Okay.
Your Honor, if I may.
Right.
Yeah.
Go ahead.
Ms. Richardson, if you can, when you move out, make sure that you turn your keys into the office. If you have to leave it in the drop box, if the closed, put your name and your apartment number on it so that they know that you moved out and they can process that move out so we can get this case.
Okay.
All right. Thank you, Ms. Richardson. Take care.
Thank you. You too.
Evergreen Apartments versus Madison Hines and Ashton Mathis.
Jillian Engen for plaintiff.
All right. Mr. Mathis? Oh, where are you? Oh, there you are. Oh, I've got you. What is plaintiff's claim?
I have a balance including court costs of $2,820.93.
All right. Mr. Mathis, how are you intending on getting that paid?
I have $1,600 right now. I just switched jobs and me and Madison broke up, so she's like not currently living with me anymore. I could get it paid in like a week. I have $1,600 of it now.
All right. So here's what I'm going to want you to do.
Yeah.
I'm going to adjourn your case out to July 10th, 2026 at 1 p.m. That's an in-person hearing. I want you to pay the $1,600 to the complex today. Okay.
Yeah.
Get that paid in. Then your July rent's going to click in, but you probably at least will be there. But you think you can get everything paid within a few weeks or a couple weeks?
Yeah. No. You know I can get everything.
Okay. If you get everything paid before that court date, and you have a zero balance, you don't need to show up because they're going to dismiss it.
Good.
Okay. All right. Thank you.
Yep. Thank you.
Glencoe Hills versus Shayna Williams and Jacqueline Williams. Or I'm sorry, Jacqueline Murphy.
Jillian Engen for plaintiff.
Hello, good morning.
Good morning. How are you?
Can you hear me?
Yes, we can hear you.
Hold
Can
on
you
one
hear
moment.
us?
I got to take my headset off. Okay,
Wow.
good morning.
Like 8, you got like 8 headsets. What's up?
I'm working.
Oh, okay. Never mind. Don't yell
Yeah,
at me.
I'm doing what you're doing. I'm working right now. Good morning,
All right.
Judge.
Good morning. All right. What is the plaintiff's claim?
I have a balance in court costs of $2,423.89.
All right. Ms. Williams, how are you guys intending on getting that paid?
I just paid $500 and I'll have, I believe, upwards of $1,500 by next week, Thursday. And I'll have the
Okay,
rest
so-
paid off before the 10th. I was listening to everybody else. I have it all paid off before the 10th.
So you're going to pay 500, or you
I
paid
already
500,
did.
and you're going to pay 1,500 by the 3rd, next Friday?
Yes.
Okay. So you're going to pay 1,500 by July 3rd. Okay. And so what I'll do is I've indicated that in the file. We'll adjourn you out to July 10th, 2026 at 1 p.m. That's an in-person proceeding, but if you have everything paid, then they'll dismiss it. But otherwise, I'll need somebody to show up at court. Okay?
Okay, thank you.
Thank
And
you.
enjoy
Have
your
a good
day
night.
off on the 4th,
Yeah.
too.
Yes, my one day
Just
off a year.
Just
All right. I will. Thank you.
Your
Glenn,
Honor,
go
just to
ahead.
clarify,
Yeah.
sorry, Your Honor. Just to clarify for Ms. Williams that if it's not to his balance before July rent will have to pay this.
She's
well
breaking up.
before
I
this
can't
case
hear
gets
what she's
dismissed.
saying.
Yeah. What she's indicating to you is that if you get July paid off before July ends, or June, if you get everything paid off before June ends and July doesn't kick in, then they're going to dismiss the case.
Okay, it'll all be done.
Once we go into July, then you need to make sure July's paid too.
Okay,
That's what she was indicating. All right. Thank you.
thank you.
Thank you, Your Honor.
Glencoe Hills versus Kathy Ann Haynes.
Good morning, Your Honor.
Good morning. All
Jillian
right.
Ingen
What
for
is
Penn.
and Anthony Haynes, I should also say. And what is plaintiff's claim?
I have a balance including court costs of $1,816.97.
All right. Ms. Haynes, how are you intending on getting that paid?
I can pay $1,500 by Monday, the 7th.
All right. So you can pay $1,500 by Monday,
Mm-hmm.
the
And-
29th.
And then
All
the
right.
balance can I do the remaining balance on the 13th, or do you need it earlier than that?
Okay. So on the 13th, you'll then have, because it'll be your next check is
Right.
basically what you're, right? Okay.
Mhm.
So we'll just count on the 1,500 at this point. I'll adjourn you out to July 10th, 2026 at 1 p.m. That's an in-person hearing. Okay. And then we'll see where we go once that 15 is paid in.
All right.
All
Thank you.
right. Thank you. Have a good one.
You too.
Glencoe Hills versus Miguel Lopez and Rashay Collins and Samuel Lopez.
Jillian Ingen for plaintiff.
Lopez Collins. You may proceed. I don't have it.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $3,071.27. Court costs are $253 for a total of $3,324.27. Plaintiff is requesting a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession redemption amount in the amount requested, writ issue in 10 days. Glencoe Hills versus Willie Williams.
Jillian Ingen for plaintiff.
Oh, there's Mr. Williams. Oh, good morning, sir.
Good morning.
All right. What is plaintiff's claim?
I have a balance including court costs of $2,488.16.
All right. Mr. Williams, how are we intending on getting that paid?
Well, I was going to reach out for some assistance. I also have $1,000 today. And then in less than a week, I can have $500 as well as trying to reach out to some of the agencies.
All right. So here's what we'll do. You paid the $1,000 over to the complex today, okay?
Yes, sir.
I'll indicate that sometime next week by say the 3rd, you're going to pay $500.
Yes, sir.
All right. I'll adjourn your case out to July 10th, 2026 at 1 p.m. That's an in-person hearing.
Okay.
Okay. And then if you apply for assistance, what you'll need to do is make sure that there's a form in the court papers you got.
Yes.
That's called a rental assistance form, or you can get one at the front counter to the courthouse.
Okay.
You need to fill that out and let the court know what agencies you applied to.
Okay.
Okay. But you got to do that by Wednesday of next week.
Okay.
Okay.
Yes.
Fair enough.
Yes.
All right. Thank you. We'll see you in a couple weeks.
Okay.
Have a good day.
You too.
Glencoe Hills versus Andrew Jacobson.
Jillian Ingen for play.
You said he's here.
Yeah, Andrew Jacobson.
Oh, there he is. Okay. And what is plaintiff's claim?
I have a balance including court costs of $3,322.32.
Okay, Mr. Jacobson, how are you intending on getting that paid?
I get paid on the 7th and the 21st of next month, so I can have it completely paid by the 21st of next month.
Okay.
And
so
that's
how much
including
did you
the
pay
July
by
rent.
Pardon?
And that's including when the July rent kicks in, I'll be able to pay all of it.
So let me ask you this. On the 7th, how much can you pay?
I can pay minimum $2,000, but most likely I'll do $2,500.
Gotcha. So sometime between that and 25.
Yeah.
Okay.
And then
So
the
I'll
remaining
adjourn
on the
you out.
21st.
Yeah, no, I understand. I'll adjourn you out to July 10th, 2026 at 1 p.m. Get those payments in, then we can see exactly where we are at that point and how we're going to proceed forward. Okay.
Yep.
All right. Thank you, sir. Have a good weekend.
You too. Bye.
Glencoe Oaks versus Renal Hodges.
Jillian Ingen for plaintiff.
He's here. There he is. Good morning, sir.
Good morning.
All right. What is plaintiff's claim?
I have a balance including court costs of $6,153.49.
All right. Mr. Hodges, how are you intending on getting that paid?
Yes, I'm actually, I'll be out by the 30th of this month, and I'm going to set up a payment plan with the complex.
Got it. So you're moving.
Yes.
All right. So here's what you need to do. You need to move out. You say by the 30th. I'm going to adjourn this case to the 10th, 2026 at 1 p.m. Okay.
Okay.
And you got to make sure that you turn your keys in, make sure they know that they're your keys and everything like that. And once you're moved out, since this is a possession case, they'll likely dismiss it, and then you can just deal with them on a payment plan. All right?
Okay, sounds good. Thank you.
All right. Thank you.
All right.
Glencoe Oaks versus Patrick Foreman.
Good morning, Your Honor.
And the more important person, Susan Foreman. All right.
I like you. Thank you. You made my day.
Good morning. All right. What is plaintiff's claim?
I have a balance including court costs of $5,465.81.
All right, folks. Okay. How are you intending on getting this paid?
We've applied for rental assistance, which we can file the DC 539 form, but our lease is up on July 19th already, so we were hoping to work with the complex on a payment plan.
Okay, so July 19th, you were looking that you were probably going to move out and do that, right? Yeah. Okay, so you can still contact the complex and try to work something out. Okay, what I will do is I will give you your adjournment to the 10th, 2026 at 1 p.m. Okay, that's an in-person hearing, but I'd still work with the complex to see what you can work regarding a move out.
Okay, perfect. Thank you so much.
Thank you so much.
All right, thank you.
Happy 4th.
Yes, and to you. Take care.
Thank you.
Thank you.
Court calls the case of Gulfside Lake 1 and 2 versus Shatia Brown. Hello, Miss Brown. I see her there.
Good morning.
Good morning. All right. Where did oh, she's back. Hold on. Okay. Ms. Endon, you're breaking up quite a bit here.
I'm sorry, I muted my video. Let me know if that helps.
I didn't even understand.
Something that helps.
Which is a no.
Okay, can you hear me now?
No, she's still breaking up. I can hear you, but you're breaking up still.
Thank you. Let me see what I can do.
All right. I'll let her do that. Ms. Brown, hold tight for a moment. I'm going to go to another complex and then we'll come back to you, okay?
Okay.
Northfield Estates versus Frank Dussault.
Good morning, Your Honor. Rachel Dornbush, Palace Law on behalf of the plaintiff.
Okay. Frank Dussault, not checked in. If you'd like to take a default, raise your, do you solemnly swear or for testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. Again, for the record, Rachel Dornbush, Palace Law on behalf of the plaintiff. Your Honor, there's rent to retain of $5,191.65. Costs are $216 for a total due of $5,407.65. And we'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested, writ to issue 10 days. Northfield Estates versus Lauren Kakali. Lauren Kakali, not checked in. You may proceed.
Thank you, Your Honor. There is rent to retain of $4,598.98. Costs are $216 for a total due of $4,814.98. And we'd ask for a default possession only judgment with a writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ to issue 10 days. Northville Crossing versus James Barnstead.
Easier.
Your Honor. Oh, there you are. Good morning. All right, what is plaintiff's claim?
With cost $3,131.47.
All right. And sir, how are you intending on getting that paid?
Your Honor, I apologize to both you and the landlord. This is actually unfortunately tied up in a divorce I'm having with my wife. She is currently occupying the residence. She's a registered nurse. I'm a 100% disabled veteran. She's been refusing to assist with any bill payments. She was in nursing school and I was getting BAH from my GI Bill that I let her use. As soon as she stopped going to nursing school, I stopped receiving that. But because of the status quo laws, when you file for divorce, I was legally required to continue to pay all the bills. I couldn't afford to pay the bills and pay for an attorney to fight for custody of my son. So we are in the situation we're in right now. My wife's last statements was that she would help me bring the balance up to zero by the 1st. We have more than enough money between the two of us to pay that. She makes $60 an hour as an RN. I'm a 100% veteran, so I get the government pension. And then I also work part-time as a security guard for Department of Corrections.
Gotcha. Okay. So you guys think that you're going to have this paid by the 1st?
Yes, Your Honor. If it's at all possible, if I could have the landlord add my wife to all future documents because we kind of got some legal warfare going on where her attorney is basically stating that everything is on me because her name does not appear on the documents, even though her and I bought the home together 16 years ago. We have lived in the home for the past 6 years.
Hold on. All right. Because I don't think any of us want to be involved in the divorce, but listen, okay. Is she on the lease or are you the one on the lease?
Your Honor, this was kind of out of the blue, and I believe the last time we renewed it that I was the only one who signed on it. But like I said, she has been with me at the residence for 16 years, and our initial lease we signed.
No, I got you, sir. But I'm just saying they can't just add her without her permission unless she's on the lease.
I understand, sir.
Okay. So here's what I'll do. If you guys get this paid before the 1st, they'll dismiss the case. If it goes over into July, July's going to get tacked on, and then we've got to deal with that. Okay?
Yes, sir. Like I said, we have the financial resources. It's just the stupid legal stuff.
All right. So what I'll do is I'll adjourn this to July 10th, 2026 at 12 noon. That's an in-person hearing. But if everything's paid, then you're good. Okay?
Yes, Your Honor.
And Your Honor, just to clarify from Mr. Barnstead, if he goes in on the 1st to pay the $3,131.47, July will be due on that day. So you'd have to pay this by June 30th if you did not want the July balance to be included in this case.
Yes, ma'am. I get my VA disability check on the 30th. My wife is saying she's going to give me half the money, and I should be able to pay both July and pay everything up, including July, on the 1st.
Perfect.
Got it.
Thank you.
All right. Sir, what branch were you?
I was in the Army, sir.
Okay. I'm not going to hold that against you.
Marine?
My dad was in the Navy, so I have to say that kind of thing to you. All right. Okay. All right, sir. Take care of yourself. Have a great weekend.
Thank you, sir.
Northville Crossing versus Jason Bradley and Makisha Crawford.
Good morning, Your Honor. Jason Bradley here. Unfortunately, my wife is very sick today, so she's not with me.
Okay, that's fine. Well, I hope she feels better. I shouldn't say that's fine. But all right, Ms. Dornbush, what is the plaintiff's claim?
With cost $2,332.75.
All right. And Mr. Bradley, how are you guys going to get that paid?
So I'll be able to pay $1,000 on Tuesday, the 30th. And I've also applied for SER assistance with the state of Michigan. I do have some other resources that I'm looking into to try to get that taken care of before the 1st, but I know for sure we'll be able to have it taken care of by the 10th, before the 10th.
Okay. So if you apply for an SER or anything along those lines, how many people are in your apartment?
It's myself, my wife, and 3 children.
So 5? Okay. Just so that you know, that the most they would give you if that happens is about $870.
Okay.
Okay. So the other thing is you need, there's a form that came in your packet called a rental assistance form.
Okay.
If you apply for an SER, you'll need to fill that form out, get it to the court by Wednesday. Okay.
Okay. I certainly will. Thank you.
All right. Pay the $1,000 to the landlord. I'm going to then adjourn this out to July 10th, 2026 at 12 noon. That's an in-person hearing. All right. But if you got everything paid, including July, then I don't need to see you guys.
Okay.
Okay.
All right. Thank you, Your Honor.
Thank you. Have a good one.
All right. You too. Have a good 4th of July.
And you do the same. Tell your wife I hope she feels better.
Thank you.
All right. Northville Crossing versus Ardell Carson. Pardon?
She's here.
Ms. Carson? Oh. She's working it.
There we go.
All right.
How you doing,
Good
Judge?
morning. I'm doing great. All right. What is plaintiff's claim?
With costs, Your Honor, $635.73. And Your Honor, just to clarify, I think the person that signed in is an occupant, Ardella Carson, but that the named leaseholder, Mr. Ardell Carson, is not present.
Got it. Okay.
Yeah, I'm his daughter.
Okay. That's fine. I just thought maybe we had dropped an A on the gotcha. Okay, so it's $635.73. How are you guys going to get that paid?
We had our intake interview with Hawk yesterday.
Okay.
So they're going to be working with us, and we go see them again on June 29th at 9:30 a.m. for our second.
June 20th. Okay.
Yes, they're going to work with us.
All right. So let's do this. Are you you guys are subsidized?
No.
No? Okay. So it's just a balance that's there. Gotcha.
Yes, sir.
All right. So I'll adjourn this to July 10th, 2026 at 12 noon. That's an in-person hearing.
Mhm.
Okay.
Yes, sir.
So if everything's not paid before the 30th, then you guys have to be there because July rent will click in. All
Yes,
right.
sir. Yes, sir.
The other thing in the packet, there's a rental assistance form.
Yes, sir.
You'll need to fill that out, get that and file that with the court by next Wednesday.
Okay.
Okay?
Yes, sir.
All right. Thank you.
Thank you. Happy 4th of July. Enjoy your day off.
Yes, ma'am. You too.
All right. Bye-bye. Thank you, sir.
Bye-bye. Northville Crossing versus Jalene Davis and Jocelyn Diamond.
Here.
Miss Dave? Oh, there you are. You're trying to hide on me.
Sorry.
All right. No, it's okay. You're good. All right. What is plaintiff's claim?
With costs, Your Honor, $2,334.72.
All right. Ms. Davis, how are you intending on getting that paid?
Well, we have $500 today, and we were going to see if they can work out a payment arrangement with us very soon.
Okay. When you say they, you were going to try to work with the landlord to set something up?
Yes.
Oh, look at that little one. All right. Then here's what I'll do. I'll adjourn this out to the 10th. You can call the landlord or you can call the attorney's office, see if there's something that can be worked out. Pay the $500. You say you have that today?
Yes.
All right. So pay that to the landlord today. Okay.
Okay.
And then we'll see you on July 10th, 2026 at 12 noon.
Okay.
Okay.
Thank you so much.
Thank you. Take care.
You too. Thank you. Happy 4th.
And to you. Northville Crossing versus Christina Johnson. And Rowe. Johnson, Rowe, neither are here. You may proceed.
Thank you, Your Honor. There's rent to retain of $672.50, cost of $250 for a total of $922.50. We'd ask for a default possession only judgment with writ issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. Northville Crossing versus Tawny Rogers. Oh, she's here. Oh, there she is. Hello.
Hello.
All right. How much is owing?
With cost $2,292.
All right. Ms. Rogers, how are you intending on getting that paid?
I have $700 that I'm going to drop off today, and then I should be able to do the rest on Tuesday.
Okay, so $700 today, and then next week, Tuesday is the 30th.
Yes.
All right. So if you get that all paid before the 30th, they'll dismiss the case and we're good. Okay. But clicks over into the 1st, then you got to show up again because we got to deal with July.
Okay.
Okay, so I'll adjourn this out to July 10th, 2026 at 12 noon. Don't know why that was sticking. Okay?
All right. Thank you.
Thank you. Northville Crossing versus Cassandra Studer. Cassandra Studer and Cheryl Richter. Oh, Miss Richter's.
Yes, I'm here.
Okay. You have a camera, turn that on, but what is the plaintiff's claim?
With cost $2,174.83.
All right. And Ms. Richter, how are you guys going to get that paid?
I can do 1,500 on the 30th and then the rest on the 8th.
All right. When you say the rest on the 8th, that would include your July rent?
Yes.
Okay. And then, so the balance plus July should be paid by the 8th. Okay, I will adjourn this out to July 10th, 2026 at 12 noon.
Okay. Okay.
And you don't have to appear if everything is all paid off, all right?
Okay, thank you.
Thank you. Take care.
Bye-bye.
Northville Crossing versus Barbara Vargo. I don't know. I don't know why her name became a tongue twister for me. Good morning, ma'am.
Good morning.
All right. What is plaintiff's claim?
With costs, Your Honor, $2,317.22.
All right. And ma'am, how are you going to get that paid?
About 2 months ago, my father was diagnosed with stage 4 cancer, and he recently just passed on May 31st. Albert Firing. And through that process, finances got messed up between his care and then the funeral expenses. But I have a life insurance policy in my name. And it's already, funds are available, but the debit card is on its way. Should be here either today or by Tuesday at the latest. And it's $25,000, and I'll be able to catch up with all my bills. And if that is later than that, I do have a message out to the VA to see if there's anything they can do to assist me through the process. But I just talked to them yesterday at MetLife, and they said it should be here Tuesday at the latest.
Oh, all right. And was your dad a veteran?
Yes, he was. Navy. Veteran. Yes.
All right.
He served out on the water during the Cuban Missile Crisis, and we at hospice even let us have a little ceremony for him, a veterans ceremony. So it was really
fantastic. All right. Okay. Look, this all work out. Okay. What I'll do is I'll adjourn this to July 10th, 2026 at 12 noon. Okay?
Okay.
Don't worry about it. You'll get it in there. The card will get here. Okay? And then if we have to take care of July, we'll take care of July. I'm not letting anything happen to you. Okay?
All right. Thank you, Your Honor.
You'll get through that. And I want to say thank you, and thank you to your family and for your dad's service. Sometimes, even though we're about to celebrate these holidays, we don't take time to step back and realize that it's people like your dad that make it possible that we're able to do that.
Yeah.
I always will acknowledge that it's people like your dad that because he served, I didn't have to. And also I get to do what I get to do. All right.
Thank you.
So thank you guys very much. And we'll see you on the 10th. Unless if everything's paid, I don't need to see you then.
Okay.
All right.
Thank you, sir.
You take care.
You too.
I think that's it. This door goes for the morning.
It is indeed. I will see you this afternoon for the afternoon docket.
Yes, ma'am. All right. Thank you.
Y'all didn't forget about me, did y'all?
Oh, man, you know what, Miss Brown? You know what? And then she got all up in the street. You didn't forget about me, and they're going to yell at
Didn't I?
I did not forget about you.
My phone about to die.
Mine too.
Oh, okay. What recalls the case? People versus Shatia Brown.
Jillian Engen for plaintiff.
All right. And what is the claim in this case, Ms. Engen?
Total, including court costs, is $2,879.94.
All right. Ms. Brown, how are you intending on getting that paid?
I just paid $2,200 this morning.
You did?
Yes.
Okay.
Sorry.
So you paid $2,200 this morning. And then how are you going to get the balance paid, you think?
I'm trying to pay that by next week, next Friday.
Okay. Next Friday is what there?
It's the holiday.
Okay. So you would, and including July rent with that, or?
No, because I'm paying all this money. So I'm trying to see if they can give me, because I actually moved, sorry, I'm not trying to cut you off, I apologize. I actually moved on the 19th of July. That'll be my lease. So I'm trying to get everything, but I wanted to ask, by me paying all this money or whatever, is it a way? Because I know they pay, like if you're not paid by a certain day or so whatever, they add another $50 or $100 to it. Is this something that they can do possibly for that? Because like I said, I move out by the 19th.
Well, here's what you have to do. You have to go in and talk to your landlord. All right? To do that. What I'll do is I'll address out to the 10th, 2026 at 1 p.m. Okay. And that's an in-person hearing, so you'll have to show up. But if you guys have worked out a move out, kind of thing, then you can come down to the court and we can figure that out too. All right.
I do. What do the 10th fall on? I'm sorry.
That's a Friday.
So I have to be to work at 3:30. I work for FedEx at the airport. And I don't know if that's going to be enough time for me to get there, you think? Or is it going to be pretty fast? Or?
Well, I never know, ma'am. All right. Well, we can do it that way, or you can submit a Zoom form. I can't say that we'll approve it, but you can submit a Zoom form. Okay.
Okay.
All right. All right.
I think
I'll set it. Okay. Work with the landlord, see what you can work out. Okay.
Yes, I'll go in there.
All right.
Thank you.
You're welcome. And you feel better for yelling at me?
Because I've been over here since 7:45. I paid that money.
So now she's gonna point her finger. She's gonna just never mind. That's okay. I'm used to being yelled at.
No, I'm not yelling at you. Sorry.
No, I got
Have a good holiday.
Okay. You do the same, Miss Brown.
Yes.
Golf side Lake 1 and 2 versus Marcus Baskin and Taylor Jackson.
Jillian Engen for plaintiff.
Hello, Judge. This is Les. How are you?
Hello. All right. And how much is owing?
Total, including court costs, is $1,695.80.
All right. And how do you intend on getting that paid?
Yes, sir. We had some financial trouble as far as my car, so I had to pay to get that fixed. I intended on having it paid by the end of this week, but because we had to secure some type of, we had to secure some type of home for our next place of living because we do plan on moving out on the 19th. Excuse us.
The 19th of July?
Yeah, so on 19th of July, excuse me, I'm sorry.
No, it's okay.
Yes, on the 19th of July, but I can have all any costs, any leftover balances paid before we move out on the 19th. It was just because we had to secure the next place, because we had already told the complex that we were leaving. And I didn't want to be an irresponsible parent and then not have a new place for them to be.
I gotcha. All right. So between now and the 10th, is there anything you can pay toward this balance, or
Yes. I can pay at least at the very minimum, like half or $750.
$750?
Yes.
All right. So I'll put you that you'll pay $750 by the 9th of July or somewhere around there. I'll adjourn this out to the 10th of July at 1 p.m. Okay, that's an in-person proceeding. All right. And we'll see what we can work out at that point. All right.
Yes, sir. Appreciate it.
All right. Take care. Have a good weekend.
Thank you. You too.
Southside Lake 3 versus Kirsten Tidwell.
Jillian Hammond. Yes. Good morning.
Oh, good morning. Well, all right. What is plaintiff's claim?
I have a balance including court costs of $2,147.
All right. Ma'am,
Yes.
how are you intending on getting that paid?
So I am a teacher. I've been unemployed since, following the Christmas break. I was unemployed. I do have a summer job. I also have a check that's supposed to be incoming on the 1st. So I think I can pay between $600 to $800 on July 1st. I know July rent is gonna kick in with that. So I also applied for the emergency rental assistance. So I have to look in my packet so I can fill out that form.
Yes,
I communicated to my Gulf side that via email that I was planning on moving at the end of July anyway. My lease is up on August 9th, but I already had planned on being moved in July. And it's ironic because actually the day that I got this notice in the mail that I had this assistant or this meeting today, I accepted a job with Detroit Public Schools. So I have a job. I just am not earning the money yet because it's summer and school hasn't started yet. So
got it. Right.
Hopefully I can get that rental assistance and I can get the balance paid.
Gotcha. Okay. So pay the $600 to $800, then I'll adjourn this out to July 10th, 2026. And you said you would fill out the packet, fill out the form, get it to us by Wednesday.
Okay.
All right. So I'll adjourn it to the July 10th at 1 p.m. That's an in-person hearing. What grade do you teach?
I teach all grades. So I teach special education.
Ah, fantastic.
Thanks.
That's you guys aren't appreciated enough.
It's quite a task.
Yes. All right. So we'll see you on the 10th. Okay. Take care. Have a good holiday.
You too. Thank you.
Stamen Family Trust versus William Brinkley.
Jillian Engen for plaintiff.
We have a dial-in in the 272. I don't know if that's on.
Okay, there's a person who's dialed in. You'll need to hit *6 and tell me who you are. Hello?
Hello?
Hello? What's your name?
I'm William Brinkley's caretaker. He's using the restroom right now. Let me get this phone to him.
I didn't get any of that.
He said reference the defendant, but I didn't hear.
Yeah. Can you say that again for me?
This is Bill. Hello?
Hello?
Can you hear me?
I can hear you. I need you to just give me your name.
William Brinkley.
Okay, you're Mr. Brinkley. Thank you. All right. What is the claim, Ms. Engine?
Your Honor, this is a termination of tenancy case. It's just a month-to-month tenancy that was terminated by a notice to quit. The notice was sent April 8th, 2026 by first-class mail with an expiration date of May 10th, 2026. Now we're here in, at the end of June, and defendant still hasn't turned over possession.
Okay. Mr. Brinkley, are you intending on moving out?
No, at this point, Honor, I'm trying to get legal services, legal aid.
Okay.
I've been here 22 years.
Okay.
Mr. Steeman was supposed to pay me after the first year so I could go back to work.
Gotcha. Okay. So what I'll do is I'll give you time to talk to an attorney about what you should do and everything like that. I'll adjourn this out to July 10th, 2026 at 1 p.m. Okay? Mr. Brinkley,
Okay,
that's an in-person hearing, so you'll have to come down to the courthouse on that day.
Your Honor.
Okay, I need to get assistance with disability and such. So could I possibly have a little bit longer to get that established?
I guess, what do you mean?
I'm a shut-in, basically. So
I got you. Okay, so here's what I'll do, Mr. Brinkley. I'll leave it on the date at that time. You always feel free to submit a Zoom form, and then we may let you appear the same way that you're appearing today.
Okay.
Your Honor.
Yes.
So I just a couple of things. My client's willing to work with Mr. Brinkley, but we really do need him to move out. Your Honor, this the building has been condemned by the building official. And so I don't think that there's really a triable issue. But I obviously my client's willing to work with Mr. Brinkley, but we're really looking for a move out date. And I don't know how long we can put that off especially with the building being
condemned. I got it. Okay. So we'll have to work something out on the 10th.
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Brinkley.
Okay. Thank you, Your Honor.
Thank you. Glencoe Oaks versus Osei Achepong and Glencoe Hills versus Devin Allen. Those matters are dismissed on plaintiff's motion without prejudice. All right. Thank you.
Thank you, Your Honor. Thank you for your patience.
Not a problem. All right. Take care. Court stands in recess. Go.
The 14A District Court is now back in session. The Honorable Judge J. Cedric Simpson present.
Good morning, folks. Adam Scott Property and Management versus Desiree Zinn.
That's me.
Good morning, Your Honor. Dominic Camden appearing. Good morning, Your Honor. Dominic Camden appearing on behalf of the plaintiff in this case.
Okay. And this is a termination.
Correct, Judge. On the docketing sheet, it says non-payment of rent, but
my face sheet is messed up, but okay. All right. It's termination. And the basis for the termination.
Judge, I believe this is a month-to-month lease, and I've not been provided, and I don't believe there is an actual written lease agreement between the parties, and my client is just desiring to take possession of their property back.
I have a lease. I would like to respectfully request one of two things. Either a dismissal based on the notice to quit being from February 19th and the retaliatory eviction statute, as I've had a wage claim open as of May 4th. It's closed now, but in the alternative, I would ask for a continuance.
Hold on.
Sorry.
What do you mean a wage claim?
Oh, there is a lease.
I had a wage claim open with Leo because I've been disputing this since early April.
Did you work for him?
I
Or
work
them?
for AK Lawn Care. My landlord is my boss. They are interlocking entities.
Okay.
And I do apologize, Your Honor. Your Honor, I did misspeak, Judge. I didn't mean to misrepresent anything to the court, but I do have a written lease agreement in my file.
You do? Yeah, I see a written lease agreement. I'm just looking. Ma'am, please.
Sorry.
But it's an agreement, but it's a month-to-month agreement. It's not for a term. All right. Well, you're entitled to an adjournment, ma'am, in this case. But you did say, what did you say about the notice?
The notice to quit was issued February 19th, and they've taken rent since then, up until June 12th.
Looking for notice. So you're saying that the notice expired on what date?
I'm not sure when it expires.
I've got it. It was March 31st, 2026. And Mr. Hamden, are you aware whether or not your clients took rent after that date?
Judge, again, this is not a non-payment of rent case, but there was a...
Yeah, but there may be a park forest issue if rent was taken beyond the expiration of the notice, which is a jurisdictional question, and that's why I'm asking, because if that happened, then I'm not going to adjourn it to another date. I'll just dismiss the action because I don't have jurisdiction.
Judge, I believe rent has since stopped. She was on a... there was a... Oh, ma'am. Judge, may I?
Go ahead.
Judge, rent has since stopped, but I do believe rent may have been paid after the date the eviction commenced. She is, her rent was being automatically withheld from her check pursuant to a consent for wage withholding because she is an employer-provided housing. So now the exact date that it stopped, that she indicated she wanted rent to be stopped, I do not know the exact date that it stopped because of payroll issues as well. So what may be
I will need to know whether or not rent was paid after March 31st, because if it is, there's a park forest issue.
All right.
So
I'll look
you can look into that. Ma'am, if you're going to file an answer or dispute the claim in any other way, you'll need to file written paperwork with the court. I'm going to adjourn and you need to do that by any answer you need to file by July 3rd, 2026. I'll adjourn this matter to July 10th. My next available date, 2006 at.
May I say something, please? Rent was taken after that. A lot of rent was taken.
Ma'am, if you would listen, I asked plaintiff if it was. I heard what you said, but I have to give Mr. Hamden an opportunity to check that. Okay. Is there anything that's unclear about that?
No, I'm sorry.
Mr. Hamden, you were going to say something?
Judge, on July 10th, I will be traveling with, well, actually, I will not, Your Honor. I'm traveling the following week, but July 10th, I will be going through orientation with my youngest son for college.
Yeah.
So I'm wondering if the court may set this over for 2 more weeks.
The 24th, you're saying?
Please, Your Honor.
July 24th, 2026 at
1 p.m.
1 p.m. That is an in-person hearing. You'll need to come down to the courthouse, ma'am. All right?
Okay. Yes, thank you.
Court calls the case of Ava Holdings LLC versus David Perverni.
Good morning, Your Honor. Robert Coots on behalf of
Ashley.
Robert Coots on behalf of AVA Holdings 43430.
Yes, I'm here.
Yes, oh, there you are. Okay.
Yep.
Okay. All right. This is non-payment of rent case.
Judge, I believe we have an agreement.
Yes.
Oh, you do. Well, here's going to be the problem. Well, go ahead and tell me what your agreement is, but there's going to be a problem with me entering it. But I will go.
Well,
because she's unrepresented by counsel.
I'm my own counsel, no?
Well, he could be. But
I am.
Oh, counsel, what's your agreement? I don't know that they can do anything with it, but go ahead.
I apologize, Your Honor. But anyway, our agreement is basically there is $8,400 due in rent, $130 is filing fee, and then $112 in service fees for a total of $8,642. And basically our agreement is that they can have until July 17th to pay it, or we take judgment
Yes.
in possession by July 17th.
Yeah.
Okay. I can't enter it today because you're unrepresented. I would get your own counsel. I have to give you the opportunity to do so. My next date is July 10th, 2026 at 3 p.m. That's an in-person hearing, but there wouldn't be any reason why on that day I could enter a judgment that would in essence be consistent with what you guys have
come up with. Okay.
Judge,
but I can't do it today.
Judge,
Yes,
would it be better if we just the previous council and we just do it to the 24th, I think you said, and if they pay, we just dismiss?
That's even
right.
better.
Yeah, that's not a problem. But in terms of plaintiff's remedy, I was thinking the same thing, counsel, but plaintiff's remedy would only be on that date then to get a judgment, which would then give them another 10 days.
I'm good with that.
Okay.
Oh, you're good. Okay. Then that's what we'll do.
We'll have something done by the 24th.
Pardon?
Oh, I was talking to the attorney, Robert. We'll have something done by the 24th.
We'll talk after the hearing.
Okay.
July 24th, 2026. What time? At 1 p.m.
All right.
Zoom or in person, Judge?
It's an in-person hearing. So
what's the address down there?
I'll tell you.
Okay. All right.
The court address, 4133 Washtenaw.
4133 Washtenaw. Okay, dokie. All right.
Thank you, Judge.
All right.
Thank you, Judge. Have a good day.
You do the same.
Okie dokie.
Danbury Park Manor versus Jane Martin. It's Janae. I'm sorry. I think that's how it is. She messes me up all.
Good morning, Your Honor. Greg Calabrese, P76393 with and on behalf of Danbury Park Manor.
She here?
Yes, I'm here. I'm trying to turn my camera on.
Oh, okay.
And you pronounced my name right this time.
Okay. You just wanted to call me out. I saw it and I said, oh no.
Yeah, you said it right this time.
All right. Okay, what is plaintiff's claim?
Your Honor, this it's an issue of well, it's a health and safety hazard at this point. I mean, the property is in complete and utter disarray. I've seen better properties at this point on hoarding TV shows. There are holes, multiple holes in the wall. There are bugs. I mean, it's an absolute infestation. It's starting to creep over to neighboring properties. The property is completely filthy. I mean, it is a complete health and safety hazard. Certainly, I could share my screen and show the court color photos of what was attached.
No, they're attached. I see it.
So,
all right.
Yeah, the demand.
Ms. Martin, what's your position on this?
Well, I have 5 small children and they be doing the most. Yeah, I understand the holes in the wall, and I told them multiple times that I will get it fixed. We don't even have maintenance for them to come fix majority of the stuff. But I just need some time. I just started back working and I just needed some time to clean all that stuff up and get it repatched up.
To do what?
To repatch the holes and stuff, like the stuff that my children did.
Ma'am, I'm looking at some of these pictures and
yeah,
there are like pieces of the wall that are
gone, yeah,
missing. I mean, not just little, there are huge pieces of walls, half doors.
Right.
And it's my understanding CPS is now involved with issues of the health and safety of the living conditions.
And they, my caseworker has been helping me since then. So.
Pardon?
I'm sorry.
What'd you say?
I said that my caseworker has been helping me with like cleaning supplies and stuff to get the house back in order.
I guess to me, Your Honor, the argument is it's sort of a silly response when the notice to quit was served April 3rd.
No, I got it, but you're saying that so, ma'am, when did you'd admit that CPS is involved?
Yes.
Are the children still in the home?
Yes, my children are still with me.
And you're saying that CPS or the worker from CPS is doing something to help you abate this problem or take care of it?
Yes, sir.
All right. She's entitled to the adjournment, counsel. So
I understand, Your Honor.
I'll adjourn this to July 10th, 2026 at 3 p.m.
Okay. Is it on Zoom or I have to come in?
No, it's an in-person hearing, ma'am.
Okay.
Thank you.
No problem.
And just to be clear, Your Honor, if we submit the request to have this hearing via Zoom, would that request be ultimately denied because you're
it will be considered.
Okay.
I'll put it to you. Okay.
I appreciate it. Thank you, Judge.
Okay, you said July 10th at 3 p.m.?
3 p.m.
Okay, thank you.
Thank you. Linden Square Assisted Housing versus Edward. Is it Simone?
Dang, how do
I see him.
Good morning, Your Honor. Michael Curran on behalf of the plaintiff.
He's here. Can you unmute, sir? Is he at 4?
Yeah, I'm trying to reach.
Can you try to reach out and see if somebody can run in and help him out? I don't know what kind of equipment they have there. If you hold down the space bar, that might do it. Just hold it down.
Alexis is on.
Who Alexis is?
Yeah.
Okay. We've got somebody coming in to help you.
unmuted now.
Oh, thank you.
Yes, there we go. Thank you.
Sorry.
No, it's okay. All right, what is plaintiff's claim?
Judge, this is a non-payment of rent case.
Yes, sir.
Mr. Seaman owes the community nearly $16,000 in unpaid rent.
What do I do that?
Okay.
I didn't build it up.
How did it get so high? I guess I'm trying to.
Well, Judge, this is an assisted living community, so his monthly rent is approximately $7,000 a month. So it doesn't take very long for it to get this high. But this has been an ongoing issue with Mr. Seaman dating back to last year. There was a previous case for eviction for non-payment last fall. The parties entered a settlement agreement to resolve that after a default judgment had been entered for money in possession. The money judgment was paid, but the balance owed at that time exceeded what the plaintiff could obtain as a money judgment, because the balance at the time, I think, was more than $30,000. And it seems that Mr. Seaman believes that by satisfying the money judgment, that he was not obligated to pay the back due rent for the total balance that was owed. So there's this whole time since last fall, there's been an ongoing existing balance where Mr. Seaman has been paying his new monthly fees, which have been applied each time to a back due balance, but he's never gotten caught up.
Got it. So this, I think I hear you. So, sir,
yes.
How are you intending on getting this paid?
There was I had gotten it completely paid, and I've been paying every month since then. And I
but
don't know what
sir,
they're talking about.
hold on. What I hear the attorney telling me is that at some point there was a judgment. It went for a certain amount. You paid the money judgment off, but you didn't catch up your entire balance.
And I started paying the balance when I took care of getting it caught up. We pulled money out of my wife and I pulled money out of the credit union and got that all caught up. And then after that, I had been getting each monthly payment. So I don't understand what they're talking about. I'm thinking double dipped here.
So, well,
so
I don't know if they're doing that. So here's what I'm going to do. Mr. Curtin, that previous judgment or that was, how long ago was that?
This, I believe, Judge, was in October of last year.
Okay. That's
fine. That's why we filed a new case.
Gotcha. Okay, so here's what I'm going to do. I'm going to adjourn this out because you're entitled to that to July 10th, 2026 at 3 p.m. And Mr. Curtin, I'll need a ledger, certainly going back to that October period. And then really, Mr. Seaman, I think the way this is probably going to go is I'm just going to look at it, do the math, and I'm going to tell you if you owe something or you don't. I mean, there isn't really a dispute here necessarily. That's just going to be where it is, just so that you know. So I'm going to get them to give me that. And counsel, do you have the case number of the previous case?
I can look it up, Judge. I don't have it in front of me. Hang on one second.
Okay. If you could just get that to my staff so I can pull that file and have everything in place for the 10th.
Hold on, Judge, I'm pulling it up for you right now.
Okay. Fantastic. He said October was judgment. You haven't? Okay. What is it?
It was a judgment, $5,000.
Okay, but you have the case number.
Yes.
Okay. All right. Never mind, counsel. We got it.
You have it. Okay.
Yes. And so that I'll have that. I'll need a ledger. And if I got to sit there and do the math, I'll do the math.
All right. Judge, before we disconnect here, I would like to try to talk to Mr. Seaman off the record. Mr. Seaman, do you have my phone number? Because I don't have a phone number for you.
No, I do not have your phone number.
Okay. Judge, I don't mind giving him my phone number on the record here. Do you have a pen to write this down?
Yeah, let me, and I'll give you my phone number. That's not a problem.
Okay. If you would please call me, Mr. Seaman, at 313-965-7586. We can talk through this and maybe see if we can get it resolved before the 10th.
Yeah, okay.
All right.
What was your name? I'm sorry.
My name is Michael Kern.
Michael Kern?
Yep.
Okay, and my phone number, you ready?
Yes.
734.
Well, I don't want, hold on.
Okay.
Mr. Seaman, I don't want your phone number out there, but so you're going to get the attorney's phone number.
Yeah, I can just get it from you, Mr. Seaman. When you call me, you can give me your phone number then.
If he gives it to the clerk's office and they update JIS, he can get it from me.
From who?
If they log out, if they check out with the clerk's office, give it to them, it'll be in JIS night.
Okay. So, Mr. Seaman, when you go out to the counter, when you leave the courthouse, just give them your phone number. They'll update our system, and then we'll send your phone number to make sure Mr. Kern has it.
Okay.
Okay, we'll do it that way. That helps protect your privacy, sir. Okay?
Thank you.
All right. Thank you, folks.
Thank you, Judge. Have a nice weekend.
You do the same, sir.
Right,
Provident Assisted Management versus Elvis Hester.
Thank you, Judge. William McInnes, P80757, appearing on behalf of plaintiff.
Gotcha.
They're not here. Did you pay for second service? You did. Looks like. If you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
All right. What is the claim in this case? Go ahead.
This case is for non-payment of rent for possession only. Rent due and owing is at $4,722.19 plus court costs of $168 for a total amount to retain possession of $4,890.19 with writ to enter after the 10-day statutory redemptive period, which would be July 6th, 2026. Again, no money judgment is requested or to be entered at this time. To the best of my information, knowledge, and belief, defendant is not in the military, incompetent, nor a minor, and the premises has been kept fit for its intended purpose and reasonable repair and in compliance with local and state laws.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with a writ to issue in 10 days. Provident Asset Assisted Management versus Avery Wright.
Thank you, Your Honor. Again, William McInnes, P80757, appearing on behalf of plaintiff.
This is Avery Wright.
Hello. Okay. All right. What is plaintiff's claim in this case?
Plaintiff claims in this non-payment of rent case for possession only $5,225 plus court costs of $168 for a total amount to retain possession of $5,393.
All right. Right. How are you intending on getting that paid?
I have contacted a family member to borrow money and can have that paid by today. And the alternative, I've also contacted Student Legal Services to speak with them.
Okay. So, but you think you're going to have somebody sort of help you out and get it paid maybe sometime today or early part of next week?
Yes, I'm working on figuring that out right now.
All right. So we'll give you a chance to talk to Student Legal Services, also see if this can get paid. And I will adjourn this out to July 10th, 2026 at 3 p.m. Okay? That's an in-person hearing, Ms. Wright. What I would indicate to you is if you work everything out with your family members and get it paid before the 30th, then because this is a possession case, they have to dismiss the case.
Okay.
Okay. If we click over into July, then we got to deal with July rent. All right. All right.
Thank you, Your Honor.
Yes. Yes, sir.
I might just request the defendant give us a call if she doesn't think she's going to be able to pay it in the next several days. Our phone number is on the pleading.
Okay.
We can try to work something.
All right. Okay. Thank you.
Thank you.
Thank you, Judge.
Then private assistant management versus Amber S. Dixian. That matter's dismissed on plaintiff's motion without prejudice. All right. Thank you.
Thank you, Judge.
Thank you, Judge. Will I get a copy of that in the mail?
I'm sorry?
Of the dismissal?
Oh, I'm sorry. I did not see you there. Okay.
I swear
well, I get a copy of the mail. I'm like, lady, I don't know. Okay. Yes, you should get a copy in the mail, ma'am. I'm sorry.
Okay. Thank you so much, Judge. I appreciate it.
Take care. Have a great
You too.
You too. Have
Bye-bye.
a good weekend. Bye-bye. Yes, I know. I see it, but I'm not going to do it. Was there a basis for it? All right. Haverhill on Clark versus Emily Johnson.
Morning, Your Honor. Lisa Schneider on behalf of the plaintiff.
She here? Okay.
I'm here.
All right. Yep, I see it. What is plaintiff's claim?
Your Honor, this is a non-payment of rent case. We're claiming rent is due in the amount of $7,452 plus $170 in court costs for a total of $7,672.
All right. And ma'am, how are you intending on getting that paid?
I have two jobs. One of my jobs has an employee assistance program, and I applied for that. Right. So I have the application pending. I'm also exploring taking out a loan against my insurance policy. It has a cash value of almost $3,800.
Got it.
And
okay.
I looked into other resources, HAWK, the Housing Act of Washtenaw County, and they said if I could get the balance down to $3,000, then they could help me.
Right. That's the first requirement. Okay.
Yes.
So will you get an answer on the employee assistance program anytime soon? Do you know, or?
I'm not sure. I'm going to email the person that I've been working with for my application and see what they say today.
Okay. And then how much, ma'am, is your monthly rent?
$771.
$771, something like that. Okay.
Yes.
So to give you an opportunity to do all of that, I'll adjourn this out to July 10th, 2026 at 3 p.m. Okay, that's an in-person hearing. All right. And ma'am, I'd also suggest if you apply to certain agencies and things, that there's a form called a rental assistance form in your packet. You'll need to fill that out and submit that to the court by Wednesday.
Wednesday.
Right.
Rental assistance.
Yeah, it's called the rental assistance form. If you don't see it in your packet, you can also come to the court and get a copy.
And you said July 10th at 3 p.m.?
At 3 p.m. Yes, ma'am.
Okay. I'm going out of town to visit my parents they're in their late 70s and I haven't seen them in a few years. And I won't be back until like after the 4th of July. Is there something we can do about the Wednesday for the rental assistance that I have to fill out?
She can fax it that way.
Yeah, and I.
Or not fax it.
I will link in chat to obtain.
To do what?
With the link in chat to obtain the 4-minute sheet.
Okay. So, ma'am?
Yes.
What you can do is my staff's going to put the link for you to get the form. Okay, if you don't have it there, and then you can fill it out basically online and then email it to us.
Okay, so it's gonna go to my email?
No, okay.
No, you're going to put it in the chat on right now.
Okay.
Got that?
Yes.
Because I am not going to be responsible for you not seeing your parents and being a bad child. I'm not. No.
Thank you.
Yeah. You're already in trouble, so I'm not. All right. Okay. So we'll see you on the 10th. Okay, ma'am?
Thank you.
Thank you, Your Honor.
Thank you. And just these other ones, Haverhill on Clark versus 5E and Selene Townhomes versus Quincy Jones. They're not here, right? Those matters are dismissed on plaintiff's motion without prejudice. All right. Thank you. Huron Vista versus Rebecca Elledge.
Good afternoon, Your Honor. Attorney Samantha Sprague, 1931, appearing on behalf of the plaintiff.
She was here.
She was here?
Yeah, she keeps dropping.
She keeps dropping. I'll pass it briefly and get to the end and deal with it. Huron Vista versus Alicia Moore.
Attorney Samantha Sprague, 1931, appearing on behalf of the plaintiff.
Not check in if you'd like. Hello, word. I just heard her, I thought.
I'm checked in, Your Honor.
She's a phone call. Got it. You're Miss Moore?
Yes, I am. Hi.
Hello. All right. What is plaintiff's claim in this case?
Yes, Your Honor, we do show a non-payment of rent. Currently, there is past due rent in the amount of $4,047.81, along with court costs of $240.81, for a total of $4,288.62.
All right. And Ms. Moore, how are you intending on getting that paid?
So one, there's a little discrepancy with that amount. That's not what my paperwork says, but anyway, whatever the amount, I am working. I recently just gave them about almost $5,000. So I'm gonna go ahead and pay this off as well. I just need to get to my paycheck.
You need to get your pay.
Yep, I just need to get paid because my job expires for the school is out. So I'm working a second job, which is catching up. I got to catch up. And so, and also I did reach out because somebody said that I can get help. So I called Hawk and they said if I pay it down to about $3,000, they'll help me. But I need to do it at a certain time because they only have so much funding. So that was my plan.
All right. So between now and the 10th, how much can you pay?
Well, I don't get paid to the 10th.
Gotcha.
So,
okay. So
yeah,
here's what I'm going to do. Here's what I'm going to do,
there.
ma'am. I'm going to adjourn this out to July 10th, 2026 at 2 p.m. That's an in-person hearing. If you applied through Hawk or any other type of agency, there's a rental assistance form in the packet. You'll need to fill that out and submit it to the court by this upcoming Wednesday.
Okay.
Okay.
Will they'll give me something, because me starting this new job, they already gave you today. Can I get something to help me? Because the demand is they're very strict on that 90 days, no call off.
I got you. So what you can do is you can submit a Zoom form.
Okay.
Okay. And then we'll strongly consider it. Okay.
Okay, thank you.
Thank you. Huron Vista versus Jasmine Scott.
Attorney Samantha Sprague Pete, 1931, appearing on behalf of the plaintiff.
He's here.
I'm here.
Scott. Oh, there
Yes,
she
sir.
is.
I'm here.
Okay. All right. How much is the plaintiff's claim?
Currently, we show there is $3,760 as well as court costs in the amount of $239.72 for a total due and owing of $3,999.72.
All right. And Ms. Scott, how are you intending on getting that paid?
Well, actually, I had already started paying on it a couple of months back after the Miss Sheena had said she would help me by removing some of the late fees. My oldest son's school, Huron High, they had sent her a check for $300. My youngest son's school, Carpenter Elementary, they had got help and got a check sent through St. Vincent de Paul for $200. As of right now, she emailed me and told me that Alpha House had sent her a check. So there's a check up there right now that she said was a good check and that she was waiting for them. I guess she's waiting to see, I don't know why, if she can put the check through. But because I guess they had made some mistakes back in January and February. I was in limbo waiting for an accommodation for my oldest son.
Ma'am, how much was the check?
She didn't tell me. She just emailed me yesterday or the day before and said that there was a check up there.
Your Honor.
From Alpha House. And
yes, counsel.
If I may, in this particular situation, my client was advised by Alpha House not to cash the check, given that Ms. Scott's assistance had expired on December 31st. Alpha House had erroneously sent multiple checks, 3 of which have bounced. And so this final check that was received apparently is an error with their system where they're sending out checks that are not approved, and then they are bouncing. So the check that my client is in receipt of, we have been informed not to cash that, and that, again, my client was informed that Ms. Scott's assistance terminated on 12/31 of 2025, which is why those other ones that were sent by Alpha House bounced.
Okay.
Oh, wow. Okay. Can
All
I also
right,
say
ma'am.
something? Oh, I'm sorry.
Between now, well, you're going to have your July rent kicking in. So.
Sorry, can I also say something? I apologize. Also, I had did a decrease in rent with CMA. So as of June, my rent is supposed to be $0, and I'm supposed to be getting a basically like a sort of a stipend or some sort of assistance, like a small check or whatnot. But because I was laid off, I work at Eastern Michigan University as a dishwasher. I was laid off for the summer because the kids are off. So I did a decrease in rent, and they put Section 8 put my rent at they put it at $0, but I still had put a $140 money order up there because I wasn't aware of the decrease until I checked the mail. And I also had asked Ms. Sheena, was there anything that we could do to work it out? Because my boss literally just called me and she asked me to come in on Saturday, this previous Saturday and Sunday. And Ms. Sheena said we could work something out if my boss was to email her from HR, something that proved that I was back at work. My boss texted me this morning and she apologized and was like, do you still need that? She said she had just sent to Ms. Sheena and myself from HR proof that I was back at work. But yes, I did already start paying on it. The schools had already started helping me pay.
Ma'am. All right, here's what I'm going to do. I'm going to adjourn this to July 10th, 2026 at
2 p.m.
2 p.m. All right. You need to figure out how you're going to get this paid, look at any adjustments in rent, and see if you can work something out with the landlord. Okay?
Okay, I can do that. I'll also go through my job too, because I work for Eastern, so I'll try them too.
Huron Vista versus Jermaine Wilson.
Attorney Samantha Sprague Pete, 1931, appearing on behalf of the plaintiff.
They are not checked in. All right, and They're not checked in. They're not here. If you'd like to take a default, please raise your right hand. You solemnly swear or affirm testimony you're going to give will be the truth, whole truth, nothing but the truth. So help you God.
I do.
Go ahead with you.
Thank you, Your Honor. We do show that there is currently past due rent in the amount of $4,771, along with court costs in the amount of $239.72. To the best of my knowledge, the unit was kept fit and habitable for its intended purpose. The defendant is not a minor, nor in the military or incompetent. We are requesting a 10-day default judgment as to possession.
All right. Judgment to the plaintiff. That is by default for possession. Redemption amount, any amount requested with the writ issue in 10 days. What was your total amount, counsel?
$5,010.72.
All right. Thank you. Huron Vista versus Nia Smith.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Nia Smith here.
Okay, there she is. All right. What is plaintiff's claim?
Yes, Your Honor, this is a non-payment of rent. We do show that currently there is past due rent in the amount of $3,503.50. Additionally, we do show that the security deposit of $1,588 has not been paid, as well as court costs of $240.81. For possession, we would respectfully request $5,332.31.
Ms. Smith, how are you intending on getting this paid?
Yes, so I sent in the proof of my tax return that'll be coming for $3,362. I should be getting that within the next week or two. And then as far as the $1,500 security deposit, I actually worked for Huron Vista and they let me go while I was 5 months pregnant. And I've struggled to find a job since. I gave birth to my son and I was not able to work for a little bit of time. But now I'm able to get back into the working field. I'm going to get assistance from a family member to pay the rest of the balance, but the $1,500 security deposit was never something we discussed when I moved in as an employee.
Got it. Let's see where it is in the lease. All right. Good. Okay. Here's what I'll do. Let me adjourn this to July 10th, 2026 at 2 p.m. Okay? And then we'll see exactly where we are at that time. Okay, ma'am? But I'd get as much paid as you can because your July rent's going to click in soon.
Absolutely. Thank you so much.
Thank you. Huron Vista versus Moesha Harrison.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
And Ms. Harrison, how are you?
I'm good. How are you?
I think I'm okay. All right. Pardon? It's on my sheet. Oh, they did send something. All right. And you're currently on the wait list for additional funding that's available for the case to process. All right. How much is the plaintiff's claim?
Currently, we show there is $3,345 in past due rent, as well as court costs, the amount of $240.81, for a total due owing of $3,585.81.
Okay. All right, Ms. Harrison, how are you intending on getting that paid?
I've been working, Mr. Johnson, he's on here. I've been working with him as far as getting help with my rent. I just recently started working probably like 3 weeks ago. So I'm slowly trying to make payments, but I have been looking for rental assistance.
Got it.
I was out of work from having my baby in December and just now getting back into working.
Right. We have you on the list that you were looking for rental assistance. Somehow you're going to have to get the balance down though, because they're not going to even consider you until you're at about 3,000.
Okay.
And now I have July rent clicking in. So you've got to get something paid if that for assistance. You follow me?
Yeah.
All right. What I will do, I'll adjourn this out to July 10th, 2026 at 2 p.m.
Your Honor.
And there.
May I?
Hello. Yes, sir.
Yes, Your Honor. I'm sorry. Damon Johnson here from the Share Initiative. As Ms. Harrison stated, that we've recently received her case, and we are working with it. And I apologize for the late notice. I was hoping to speak with the attorney and try to offer some kind of resolution and a settlement today. I understand that we'll have to adjourn, but we're prepared on behalf of the Share Initiative, which is a local nonprofit here. We're prepared to offer a settlement resolution today if the court pleases.
Well, here's what you can do. You should have the attorney's office phone number. No, you can give them a call. You can give them a call today after the hearing. Whatever you guys come to might be fine with me, but I won't have it done here on the record.
Okay, can I have the attorney's number if that's okay?
Yeah.
Certainly. If you give me just a moment, I can get you that. It is 989-933-3106.
Repeat that for me, please.
989-933-3106.
3106. And if I give you a call here within the next hour, am I just asking for attorney Samantha Sprague?
So, Mr. Johnson, you would want to call with Miss Harrison.
Okay.
And then, that's my direct line. Okay. So
Okay.
if you do a joint call with Miss Harrison, then I can speak to you and we can negotiate that because you're not an attorney, correct?
Correct.
Yep. If you call with Miss Harrison.
I watch a lot of court TV, but I'm not an attorney.
All right. Yeah.
That only makes you dangerous. All right.
Thank you.
All right. I've set it for the 10th.
Is that in person or over Zoom?
That is in person.
Okay. And 2:00.
2:00. Yes.
Okay.
Ma'am.
Thank you.
All right. Thank you.
Thank you.
Rez at Huron versus Dennis Wilson.
Attorney Samantha Sprague, PA 1931, here on behalf of the plaintiff.
You got him here.
Yep, he's here. I'm here.
I'm here. Okay,
Yes.
there you are. Okay. All right. How much is the claim?
Yes, Your Honor, we show that currently there is past due rent in the amount of $2,235.02, as well as court cost in the amount of $219.72, for a total due owing of $2,454.74.
All right. And Mr. Wilson, how are you intending on getting that paid?
With help from family.
All right.
My son's been helping me. He already paid some of it.
Okay.
He told me that he had an agreement with some housing people that he'll pay half and they'll pay the other half.
Okay. Do you know when that's going to happen?
No, I don't. I know that he sent his half in through his mother, and she came over a few days ago to take it to the office.
You don't know how much that was?
No, I don't, because they did that around me. They just did it and then told me after the fact.
Okay. And I take it, counsel, you don't see a check in there.
No, I'm messaging my client right now to see if there was. Okay. It looks like there was a payment made the other day of $1,000. So that would not be reflected in the amount I provided to the court. If you can give me just a moment, I can amend that.
Okay.
It would be.
So that would bring.
Yeah, I'm sorry.
It'd be 1454.74.
Correct, Your Honor.
All right. Okay, and so Mr. Wilson?
Yes.
You think there's somebody that's going to pay that other half or that other part of that?
Yes. My son was talking to some housing people, and they said that if we can come up with half, they'll pay the other half. My son sent in his half, so that's all I know.
Okay, let's do this, okay? I'm going to adjourn your hearing to July 10th, 2026 at 2 p.m. That's an in-person hearing. Maybe everything will get paid off by then, all right?
How much is owed?
$1,454.74.
Okay.
Okay?
Okay.
All right. Then I'll do that. I've given you a new hearing date. That's an in-person hearing, okay, on that date.
Okay.
All right. Thank you, Mr. Wilson. You have a good 4th of July.
Thank you.
Thank you. Huron Vista versus Rebecca Elledge. She was here and now is not.
Yeah.
Again. She popped in. She was all right. Well,
Your Honor, I'll be back at 1 o'clock if she comes back to the court.
Okay, we can do that. All right. Yeah, just they're here at 1, so if she can log back in at that time, that's a good idea, Counsel. Then I'll just hold that hearing then, because she's been popping in and out, so she was at least here.
Okay.
Rather than turn it out. Okay.
All right. Thank you, Your Honor. We'll see you in a couple of hours.
Yes, ma'am. Augusta Woods versus Eric Roden.
Good morning, Your Honor. Jennifer Warbling appearing on behalf of the plaintiff.
She was here.
And Richard Robbins. Oh, hold on. Robbins, I can't hear you. Are you connected to audio? Yeah. Tell you what, do this for me. I'll pass your case, sign off, sign back in, make sure you connect to audio, and then we'll see if we can hear you, okay? I'll handle these other ones, and then we'll wait for you to come back. If you understood me, give me a thumbs up. And that'd be a no.
Oh, she said okay in the chat.
Oh, she put okay in the chat. Okay, she's doing it in a sophisticated way. All right. Okay. All right. Augusta Woods versus Paul Reedy.
Good morning.
Good morning, Your
Jennifer
Honor. Shoot, sorry.
Good morning, Your Honor. Jennifer Warbling appearing on behalf of the plaintiff.
Hello, Mr.
Sorry about
Reedy.
that.
How are you?
Sorry about that, man. I'm sorry.
No, it's all right. Okay. What's plaintiff's claim?
Plaintiff's claim, the rent to retain possession is $953.22. The costs are $260. The amount that's outstanding is $1,213.22.
All right. Mr. Reedy, how we going to get that done?
Just kind of briefly explain, my minor daughter has been living with me since October. Yesterday, I was awarded full physical custody of her. Big relief. I'm also now labeled as her payee, so there's more money coming to my home. I will have it all paid this next month on the 2nd. So yeah, on the 2nd, 100% everything, plus next month.
On the 2nd of July?
Yes, sir.
Okay. So you're gonna get the balance paid. All right.
Yes, sir.
What I'm gonna do is I'm gonna adjourn it to July 10th, my next available date, 2026 at 2 p.m. If you get it all paid, I don't need to see you. There's really a doubt in my mind, Mr. Reed, you're gonna get it done, so.
Yes, sir. So there'll be no more fees?
Well, you're gonna have your July rent, and there might be a late fee.
Yeah. I meant court fee. I mean, lawyer fees.
No, the amount they gave includes the fees that they can charge.
Okay, it'll be paid on the 2nd. Thank you so much, Your Honor.
All right, take care and have a good 4th.
Have a good weekend. Thank you.
Augusta Woods versus Papa Gaye.
Good morning, Your Honor. Jennifer Werbling appearing on behalf of the plaintiff.
Not checked.
They are not checked in. If you'd like to take a default, raise your right hand.
Right.
That's the other right hand. No. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, go ahead.
This is a possession case, and the rent to retain possession is $832.86. The costs are $195. The total is $1,027.86 with a writ date of 7/6/26.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested with the writ issue in 10 days.
Thank you, Your Honor.
Thank you. Augusta Woods versus Sean Brown.
Not checked.
They are not checked in. You've already been sworn. You may proceed.
Good morning, Your Honor. Jennifer Werbling appearing on behalf of the plaintiff. This is a possession-only case. The rent to retain possession is $3,096.21. And the costs are $195 with the total amount that's due is $3,291.21 with a writ date of 7/6.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested, writ issue in 10 days. Augusta Woods versus Tina Brooks.
Good morning, Your Honor. Jennifer Werbling appearing on behalf of the plaintiff.
What'd you say?
Not checked in.
Tina Brooks. Not checked in. You may proceed, counsel.
Thank you, Your Honor. This is a possession-only case. The rent to retain possession is $1,228.63. The costs are $195. The total amount due is $1,423.63 with a writ date of July 6, 2026.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days.
Thank you, Your Honor.
Thank you. Beal Properties versus Monica Gilman.
Good morning, Your Honor. Jennifer Werbling appearing on behalf of the plaintiff in this matter.
And Ms. Gilman is here. Hello.
Hello.
All right. What is plaintiff's claim?
This is a possession case. This rent to retain possession is $1,330. The costs are $175. The total amount due is $1,505 with a writ date of July 6, 2026.
All right. And Gilman, how are you intending on getting that paid?
I was going to try to work out a payment plan with them. I am vacating the unit. I'm currently in the process of that and nearing completion. They have agreed to give me until July 3rd to turn in the key. I'm not sure what other information you need.
No, I got you. Okay.
I'm not currently working, and I'm currently looking for work. And I've had like medical issues with my feet and back and mental health that have prevented me from working, thus landing me in this current situation.
Got it. Okay. Here's what I'm going to do. I'll adjourn this out to July 10th, 2026 at 2 p.m. This is a possession case. So if you're moved out of the premises by then, they're going to dismiss the case. and then you can work
Okay.
out how you're going to do a payment plan. Okay.
Okay, that sounds good. You said
All right.
July 10th at 2 p.m.?
Yes, ma'am.
All right, thank you.
All right. Thank you. And let's see what I got. Beal Properties versus Cristo Roads. Krista Rhodes, I think it is.
Good morning, Your Honor.
I got it. Good morning, Your Honor. Jennifer Warbling, appearing on behalf of the plaintiff.
All right. So Rhodes, if you have a camera, please. And is it's Krista or Christo?
It's Christo with an O.
With an O. Okay, so it's spelled properly. Okay. All right. What is plaintiff's claim?
This is a possession case. The rent to retain possession is $2,008. The costs are $175. The total amount that's outstanding is $2,183 with a writ date of 7/6/2026.
All right. And how are you intending on getting that paid?
So I will have a balance in its entirety paid by either July 8th or July 9th, even for July. So all of it will be paid, including July's rent, on the end of the day, July 9th.
Got it. Okay. So here's what I'll do. I'll adjourn this out to July 10th, 2026 at 2 p.m. And if everything's paid and you make sure that everything's paid, you don't need to come down to the courthouse. This is an in-person hearing. And if everything's paid, they're going to dismiss the case.
Okay.
Fair enough?
Yes.
All right. Thank you. Have a great weekend.
You too.
I think
And let me-
Mr. Robbins is back.
Yes. Court does call the case of Augusta Woods versus Eric Roden and Robbins.
Hello. Good morning, Your Honor. Jennifer Warbling, appearing on behalf of the plaintiff.
All right. Can you state your name?
Good morning, Your Honor. Teresa Robbins. I'm Richard Robbins' wife. He works afternoons, and unfortunately, he's on overtime this week, so he didn't get to bed till about 5 this morning.
Okay. All right. So he sent the big guns in to represent himself. I got it. I see how this is working.
Yes.
All right. What is plaintiff's claim?
This is a possession case, Your Honor. The rent to retain possession is $2,414.39. The costs are $260 with a total amount of $2,674.39.
All right. Ms. Robbins, how are you intending on getting that paid?
I have $500 to pay today, and then I can have the remaining paid July 8th, by July 8th.
Okay. And would that include your July rent?
Yes.
Oh, okay. So I'll just put the balance then by July 8th. I think as you may have heard me tell the other person, if you get everything paid before the adjourn date of the 10th, right, then they'll dismiss the case.
Yes.
Okay, so I'll adjourn it out to July 10th, 2026 at 2 p.m.
Sounds
Well,
great.
it's
Thank
a
you
good
so
thing.
much. You
It's
have
a
a
good
wonderful.
thing he was sleeping and doing all that overtime because you just killed it in terms of the case. All right.
Thank you.
Thank you, Your Honor.
You're good at what you do too.
All right. You take care. Have a good holiday.
Thank you, Your Honor.
You have a great holiday. Bye.
Yeah. I still have these. Augusta Woods versus Poor and Beal Properties versus Curley. Those matters are dismissed on plaintiff's motion with them. Eunice Morrissey versus Zachary Kelly.
Good morning, Your Honor. Eunice Morrissey.
Gotcha. Do we have Zachary Kelly? He's not checked in. You did not pay for second service. This is a termination. He's not here, Miss Morrissey, so I can't give you a default on the case because you didn't pay for a second service on it. So I'll have to adjourn it out to the next hearing date. And then you can take it called at that time, okay?
Did you understand?
Yeah, yes, sir. Yes, Your Honor.
All right. So I'll adjourn this out to July 10th, 2026 at 3 p.m. That's an in-person hearing. And at that point, if they don't appear, I can give you a default judgment on this case. Okay?
Okay, thank you.
Thank you.
All right. Thank you, folks. Alec, is it Sadoff versus Arnold Sadoff, if I've got the name right?
Yes, you got it right, Your Honor. This is
right.
the plaintiff.
All right. And there was no second mailing. This is termination. You are
the plaintiff.
Plaintiff. Arnold Sadoff's not here. Just like with Miss Morrissey, I can't give you a judgment on this at this time. I'll adjourn it out. If he doesn't appear at that hearing, then I can issue a default judgment.
Thank you.
July 10th, 2026, 3 p.m.
And that's at the 14A1 court?
Yeah. Yes, sir.
Thank you very much. Have a good weekend.
All right. Thank you.
Bye-bye.
Okay. And that's it. That is it. Okay. Thank you, folks. Ms. Mazur, thank you in front of the court. You have a wonderful holiday.
You as well, Judge.
All right. Take care. 14A stands in recess.
Daniel Rodriguez is called, and clause number 26CR267. There is no answer. In the courtroom, I speak notice to all of you. Yes.
Judge.
What is the law that? The bond machine. Very good. Okay, and this comes on 26CR267. They just failed to figure it out. We do that place. Wow.
Judge.
It's going to but how much it first time.
Yes, just to refresh the board, a lot of time we appeared on the limit stated on the record that he was having. After we left the board, I did get a call from the victim's mother about that he was trying to contact, respond to the house. There's been lots of repeated contact, so the state was out of bond to somebody through. So for that reason, she's not able to be here today. The child case, so the no contact order was not towards the mother. It's also been brought to my attention that she's currently filing for a protective order. I just got that information this morning. But if we need to set this for a hearing when he's here to. But we asked that the bond be increased regardless because he failed to appear.
If this bond is revoked, the warrant should be issued for his arrest. His bond in the amount of $25,000 will be ordered due to the indictment and the probable cause affidavit, which alleges that the defendant, let's see, wielded a firearm while intoxicated in front of the child and getting into a standoff with law enforcement and did not deliver voluntarily the child to a designated emergency infant care provider under the Texas Family Code as one of the conditions of this statute require. And he must where is he? Do you know where he's at? We're not around. He's not around. So where is he living now? He's not living at the home with the child, I presume.
No,
because that would be a travesty until we can get this done. You know, I don't know. I know we don't know.
According to the victim's mother, that he's not living there, but he is trying to visit that residence to see them.
Well, obviously the child. I agree with that. You can't have any contact with a complainant. And then he must be at home confinement. He's allowed. We must have a GPS so we know where he is when he's not here. He can go to and from his office, his lawyer's office in most direct route possible, to and from food, to and from work. Yeah, I'm trying to get them all covered, the necessities, and there are other needs aspects of that he too is trying to ask me and then trying to brief. All right. Flexible, so long as there's no contact with the victim and it's in the most direct route possible. So that we keep an eye on things, freeze the action as it were. I have.
Judge.
Yes. Okay. Bruce, you got some things. What are you doing? On Kendall, Andrew? Okay, what about Xavier Kane?
That I'm legal time does. This is John, the prosecutor. Okay. I'm working on that.
Okay. John West, where are you?
Right here.
There you are.
Right.
What are you going to do on
hearings on both of them, guys?
Oh, we have hearings. Good.
Yeah.
Oh, okay.
Yeah.
Something to do.
And then
that's Chadston.
Bronson, and I know Mr. Ham's got
Jovan.
That the other one is just one of them has witnesses for a new offense, but the other one's just administrative. So it'll be one will be easy, one will be a little long.
Okay.
So whenever you get ready, I'm ready. But what else you gotta do?
I don't see Ted. Where's Ted Johns? He's running late. What about Mr. Marino?
Yes, Your Honor.
Christopher Barajas, I believe. Is he in custody?
Oh, no, he's ready.
Come on it. You're invited.
I know he's not dressed well, but he just worked overnight, Judge. That's why he's came straight from work.
Hey, didn't I give you Fontenot back? I didn't know if I'd lost it. And now we recall 25 CR 1049 in the state of Texas versus Christopher Barajas. See, yes, am I pronouncing that correct? Yes. Okay. And Mr. Marino is here representing you. And as you know, you are charged with this third-degree felony of online solicitation of a minor. I don't see any other added charges, huh? So there's no enhancement here on this.
No, sir, that's it.
You're looking at a third-degree felony, which carries with it up to 10 years in prison. And nobody, of course, wants something like this on their record. That looks bad. Try to get a job or get into the priesthood and you're going to have problems. It's an announcement, and yeah, it's
getting
9 months old.
Well, I'm announcing stalemate. Ms. Moore and I, we've tried, but we're not getting anywhere. We're just going to get a trial.
All right, we just finished our 615 felony jury trial, which according to the internet is a world record, and that's what we do here. We try cases.
Can I put it out as far as possible? Because I got an intox man. I got to try a child or possession of child pornography and a sexual assault of a child all this summer.
Setting the ball, Judge. Pull through.
Okay. That takes care of that, Judge. Okay. I didn't have to bring it up.
All right. So here's the deal. After this, ain't no deal. So I mean, okay, that's what we put on. This is our. Y'all had an opportunity, and we're going to set it, and that's what we do. I enjoy. I like trying cases. Something different happens in every trial, and you seem smarter because you learn something new in every trial. So it's a remarkable thing. It's not like, oh, that was just like the other one. But that's what we do here. This is a trial, and that means, and he's eligible for probation.
Yes.
Stand by. Let me just look at this.
Don't give any record of this. No.
This for him too.
Hey, you've got a copy of this, proper cause?
Oh, yes.
Yeah, okay. Okay. It's settled the trial document. That's what should be done. Hey, Bruce.
He's in the back.
John, you're up. You just get a resetting from her.
All right.
The hearing online, I read. Okay.
No. Let me get Bruce out of the way.
Yeah. So, wait, come here. She's ahead of us.
Is Reginald Allison here? Reginald Allison, have you talked to your attorney?
Well, I haven't seen him today.
Me neither. And I'm kind of disappointed because we're late on this one.
Take off on the phone.
What's this from probation? What's the status on that?
So are we excusing?
What's the probation?
Well, Your Honor, this was just.
Is Mr. Allison doing well or not? That's all I want to know.
He's been on my case for a month and is doing well.
Okay. Yeah. Isn't that's what that's all we're looking for?
Or just to see how he's been doing.
Okay, what do we want to do next?
I mean, at this point, Your Honor, I say he just stay on my caseload and proceed the way he is. So
Great, come
I
on.
think that TRP.
Do I need another review?
I don't know. I don't know if anything happens, I can file documentation.
Hold on, everybody's talking at once. What did you say?
There's a pending FTR.
What about the motion to revoke probation? Stay.
Dismiss it.
What do y'all want to do?
We'll dismiss it, Judge, if you're done well.
Is that what we're gonna do?
No, something happens, I can refile.
All right. Mario Jobo. Thanks for being here on time.
Well,
I appreciate it. Show the respect that was always good for you. You were always nice. Okay, so Ted, we don't know where Theo is, but Mario Jobert is here, right? Mario Jobert?
Marlo.
Marlo Gilbert. In two cases, 26 CR 392 18-29833. There is no answer in the courtroom. Oh. Do we know? They never. Marlo Jubert. Two cases.
no response, Your Honor.
All right.
Yeah, hold on, it's just maybe something's back.
He's back there. State, who's got that one? Marlo Gilbert.
Judge.
Are you ready on this? John's isn't here, but I'm going to wait for him to get here, and we're going to have a hearing if we need to. It's a motion to revoke, right?
Yes, sir. I spoke with him yesterday, and from my understanding, I believe we're going to work it out.
Yeah, but it's always handy to have their presence. They're not around. He's already late. Not the first one today, which is. You know what happens in when I was in federal court for 20 years and you rolled in late? You didn't hear the end of it. And your taxes got audited. And not really about that, but generally the lawyers were on time, which was what should be happening. Okay, who's ready? Yeah.
We're ready, Your Honor.
Yeah, just insulting, but everybody in the room knows it. It's just too bad it's like that.
You brought your kids, you got my.
Let's go with you then, John. You're the guy up.
One of them is just an administrator that's going to be no independent witnesses. So you want to do that one? That'll be easy one to do first. Not Bryson, but the other one.
Well, okay. What do you have here?
I have two.
Two different
cases, two different defendants.
Chadston, Brights.
That's going to be a full hearing with witnesses and testimony to prove up trying to prove up a new offense as the basis. But the other one is administrative.
I didn't see that. He's done with that.
So he's on probation for one case, but
Jovan Hopkins.
That's just going to be you're off.
Say that again.
You're on stop.
This is administrative.
It's administrative. That's going to be easy. But you want that? Yeah. I've got a bunch of up here to answer that.
Okay, you want to go?
Hopkins would be quite easier going to go first. It's just
they're all the same. But yeah, Hopkins, Jovan Hopkins, and he's in custody?
Yes, they're both in.
All right. There is a new motion to revoke probation filed in this case, correct? And it's going to allege something different than the earlier motion to revoke probation a few years ago.
This is restitution, failing to complete the moral recognition therapy, failing to pay court's costs. And back in 22, he pleaded true. 2022, he pleaded true for failing to enter and complete the moral recognition therapy program. So we're back on that one.
Yes.
All right. Are you Jovan Ray Lede Hopkins?
Yes, sir.
Here with your attorney, Mr. West, and State's attorney. In 17-27711, there's a motion to revoke unadjudicated probation filed October 23rd, 2024. I don't know why this one's rolled on for so long on administrative, but here we are. That's headed toward 2 years. What are we doing today?
God, I believe it's just a hearing. I think all the allegations are all administrative and
we're going to deal mostly on number 2, the moral recognition therapy that he was ordered to at the beginning of probation, which he earlier in 2022 pleaded true to failing to complete that properly. So we know we'd had a deal that we brought up that was made a big deal, and he knew that was important. And so we're back today, 3.5 years later, and it's the same old thing. Correct. Okay. Does the defendant who's here with John West, his attorney, waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary?
we can, Your Honor.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. In summary, this motion states that on November 6, 2017, in this court, you were sentenced to 5 years in prison.
No, Your Honor, he was sentenced to 2 years.
Hold on. What was it? You were you were placed on deferred or unadjudicated probation for 5 years. You weren't found guilty. And that was in 2017. That deferred or unadjudicated probation has been continued through the years. And here we are today, and he's still on deferred or unadjudicated probation, correct, everybody?
That's the order.
Is that true, sir? All right. Allegation 2 states you failed to provide verification of entering and successfully completing the moral recognition therapy program as directed by the probation office. That's a violation of condition 29 of your deferred or unadjudicated probation order. And that states enter and successfully complete moral recognition therapy, comply with all rules and regulations of the program, and pay all associated costs. That was an order that you signed and I signed back on November 2017, when I was just almost a teenager. Is all of this true and correct?
Yes, sir.
Are you pleading true to allegation number 2 voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant motion to revoke probation? Your probation could now be revoked. You can now be found guilty and sentenced up to the full range for this state jail felony, which is no less than 180 days up to 2 years in the state jail. You have 162 days credit already. Understanding all of that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. What does anybody want to say?
I think, can I ask my client some questions, Your Honor?
He's under oath.
Yes. Mr. Hopkins, you never finished this moral recognition therapy. Is that true?
Yeah, I mean, but I never finished.
Okay. Tell the court about that. What happened? What went on?
When I went, they gave me the book. But then he said he was going out of money.
Did you hear him okay? You need to speak
a
loud.
little louder and clearer.
I got the book the first time, and he said he was going on vacation.
Who's he? You say he?
Oh, I don't know. I don't get his name.
The person that was conducting the class?
Yeah.
Okay, that's all I have. And he gave you the booklet and then told you he was going out of town?
Yeah, he went on vacation. He said he was going on vacation.
Okay. And did he come back from vacation?
I never talked to him again.
And did you talk with your probation officer about getting the class again? Because you've been on probation you ordered to do this a long time ago, is that correct? You ever followed back through with this to take care of it?
Yeah, I asked them. She gave me a note to call. They never answered.
So it's his fault? It's his fault. It's the probation officer's fault that it's taken you 8 years to not do anything on this requirement.
And the class they never had another class.
So it's somebody else's fault. They never had a class, so it's somebody else's fault.
Yes, sir.
That's your, okay.
Class.
Wait, hold on. What's the probation say about that? Is it your fault?
No, Your Honor.
Oh.
We actually referred him online as well to do the class. And the providers usually reach out to them. And I'm assuming he never answered or got in contact with them because he never.
Who's the probation? Who's this direct probation officer?
Me.
Okay. Oh, you've interacted with this man about all of this?
Yeah.
Well, the lady is here who's your supervisor.
Yeah,
she's saying it's your fault.
Yeah, the paper that I reached out to them, but they never reached back out to me. The paper she gave me.
What do you mean you reached out to them? This is your responsibility to complete.
The class that I'm supposed to take, I reached out to them. She gave me a number to call them, but they never called back.
How does this work?
So we refer them to PDS. It's online.
Okay, hold on. Play like I don't know the initials stand for something.
It's personal development seminars. We refer him there.
Yeah.
Write down all his information, the name, his address, phone number. I email it to them and they get in contact with him. Now it's up to him to answer the phone. If he doesn't answer the phone or doesn't reach back, then they can't ever schedule the class.
And this has been your experience as you've been a probation officer for how long now?
4 years.
And this is your experience in all cases, where moral recognition therapy is required, which is in many cases.
Yes, sir.
This is the way it works all the time.
Yes.
How many problems in the thousands of cases that we've handled over 4 years, how many problems have we had where the defendant says, oh, well, I did all I can. They never reached out to me?
Not many.
Well, I mean, does it happen?
No.
Okay. It doesn't happen. Congratulations. We have 5,000 probationers. You're the only one who can't seem to communicate, but it's your requirement. You signed a plan, you signed a contract when you were placed on probation. And what happens is you got to put out the effort. And here's the problem is that we made a mistake. I gave you a chance a while back. We had a hearing on this, and back in October of 2022, where you failed to report, failed to provide verification to performing community service, and failed to complete the theft prevention class, and failed to provide verification of entering and successfully completing moral recognition therapy. That's going on 4 years ago. And he hadn't done a thing since this last hearing of 4 years ago?
For that moral.
For that moral credit?
No.
No.
That's
45 months have gone by. Times 30 days. 1,300 days. And you couldn't squeeze it into your busy schedule? You see anything wrong with that? You're nodding. She has to take something down. Yes? Yes, I do. On balance, Ms. Vega, on balance for the defendant, how's he doing on all the other stuff? The other requirements, he's just probation. Is this just the only thing he's not doing right, or are there other problems? I know there's money problems. And I'm a little, unless somebody's going to convince me that he's got money that he's not paying.
We're not concerned about the money, Judge.
But I am, because it's an order of this court. But if they're unable to pay, that is a defense, and I honor that. Is he able to pay as far as you know money, or are you working somewhere?
At the moment.
Yeah. Well, it's hard to get hired when you got some problems here, criminal
I'm
problems.
gonna get my tweet card.
See them. You've been on probation now going on 9 years, almost a decade, and we're still having problems. See? And this moral recognition therapy is very important because it's a class that helps you make the right decisions. You seems like you're not making the right decision. We're in the same situation we're in. Let me ask you, are you employed now?
No, sir. I was
Sir?
No, sir. I was taking a class for.
Okay. What's your education status?
I graduated
From
High School.
From high school. After high school graduation, what have you done for education? Anything?
No, I was taking an IT class.
Okay. So what do you do during the day? When you're not in jail? What do you do during the day?
With my uncle cutting grass.
Cut grass? Okay. How's that going?
It was going good.
Well, how much do you make in a year?
I just paid $20 like a yard.
Okay, 20. Okay, how many yards do you cut in a month?
Like
20 yards? 20?
Yeah.
Is that right? Okay, and it's $20 each? That's 400 times 12. That's
4,800.
4,800.
Think I'm not good at math.
Are you filing income tax returns on that money?
Yeah, I was filing it.
You file?
Yeah.
Oh, well, we want copies of your tax returns. Can you get them to her tomorrow?
Yeah, I can.
Where are they?
In my phone.
You keep your tax returns in your phone?
Yes, on my email.
Probably electronically filed. Okay.
Yeah, well, good luck when your phone gets taken or something, huh? How do you, the IRS doesn't find that amusing.
Well,
anyway, that's your problem.
Yeah.
What do we want? Okay, what else on this case? We're going to move forward here. He's from the very get-go, he was charged with burglary of a building. Oh, and where are we on? Was there any restitution owed in this?
There was, Your Honor.
Is there still owed?
Yes, sir.
Yes.
How much?
$4,448.
What was the amount?
That was the amount.
Wait, he's making $4,800 and he can't get one dime to the victim? Are you kidding me?
I was gonna chop your pay when I got my ankle tagged.
Oh, you think it's been, how long you been on probation? 8 years. We're going to wait on you? You were supposed to do it immediately, start paying something back. No, it's all about, this one is, the victims don't matter. It's all about you. That's why you got in trouble in the first place. No, I don't like this.
Your Honor, another option we have, besides sending him to prison right now, is he's on deferred. You could revoke his probation or deferred and place him on regular probation to pay the restitution back, see if it happens, and there's more recognition therapy. And if it doesn't, then prison is the only option. But right now we have another option between that.
You mean like we hadn't done anything in 9 years?
I know.
He's waking up from a coma now?
I'm just giving options that's important. We're trying to get to restitution. That's another option we could do.
Okay. What state asking for? I can sense Mr. Ham's frustrated.
Oh, yeah.
We all are.
I understand.
And the victim is, I'm sure.
Judge, I would like to ask you to revoke him based upon his plea of true count 2. I would ask that whatever punishment that you give him, that we add the restitution to the judgment there. I think that's the best way to resolve this because of the
Terrible. Not.
Well, it's horrible that he's done that, Judge, but the bottom line is
It's terrible
we've
that
kind of-
the people hadn't been paid back, but he's bragging about how much money he's making.
My frustration with him is with the state jail felony. I'm not sure that we can, I think we've done all we can do underneath the legal requirements of the timeframe we can work with him on this probation.
What's his restitution? How much?
$4,448.
That's great.
Anything else?
Not from the state judge.
Okay, so we're going on this motion to revoke unadjudicated probation here, I guess. The one that was trying to get the most recent one.
That's it.
The one in 24?
Yes, sir.
Yeah. All right. And this, in summary, this motion to revoke probation states that on November 6, 2017, in this criminal district court of Jefferson County, Texas, you were placed on 5 years deferred or unadjudicated probation for burglary of a building, a state jail felony. Is all of that true and correct, sir?
Yes, sir.
And allegation 2 states you failed to provide verification of entering and successfully completing the moral recognition therapy program as directed by the court in the probation office. Have you failed to do that, sir?
Yes, sir.
Are you pleading true to that voluntarily and because it is true?
Yes, sir.
Yeah. Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment for a state jail felony. And that's no less than 180 days up to 2 years in a state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. 3 states you failed to pay court assessed fees as directed. As of September 23rd, 2024, you were in arrears $9,234. My primary concern is you were ordered to pay restitution in the amount of $4,448. What is the total amount of amounts the defendant has paid over the course of his probation?
$1,421.
Okay. And that's over since 2017.
Yes, sir.
And I think we talked about that. We're going, that's going on 10 years and 120 months. And over that period of time, each month, well, you're making what, $4,800, what, per month? Is that what we said?
That's what I heard you say.
Yes, sir. That's what you said, which is times 12.
It's less than 60.
I think he said 4,000, so I think it's 4,800. I'm gonna give him that credit. So it's 4,000, which ends up being 48. 48,000 a year, almost 10 years. So my God, he's made almost $500,000 in a decade this way, and not one dime went to restitution for the poor people. Is my math right here, everybody?
I think it's a little off, Judge. Would you for you?
It says he makes 200.
Right, so 4,800 a year.
No, it's 4,800 a year.
Right, times 10, so
which is
40,000.
4,800 a year, not 48,000, 4,800 a year, right?
Right.
Okay. And this has been 10 years, so that's 48,000 over a decade.
Right.
But not one dime has gone back. And he's paid a total of 1,000.
$421.
1,420. Where'd all the other monies go?
2 years. I think 2 years.
How old are the children?
I got a 1 year old, 1 year old.
Okay. How about them? What happens to them when you go to prison? Hmm? Do you care?
Yeah. Yes, sir. All right.
You know, that's where we're headed.
My daughter had dialysis.
Sir?
My daughter had dialysis.
Yeah, so you don't follow your rules of probation, so you end up going to prison. Whose fault is that? It is. Meanwhile, you've got responsibilities at home and children who need care. Where's the mother of the child?
She's there.
She was?
I said she's there.
Is she employed? Well, she works in the house. Homemakers have a responsibility, and it's generally hard work.
Shutting down.
All right. What's state asking for?
Judge, reading through the original PSI, the fact that this burden of the building was a break into a pharmacy, and it was out of the kindness of the individual that owes the restitution. He made a recommendation that this young man not get any jail time then. I would have actually harped on it at the time because of the circumstances, but he didn't meet those needs. He's young. Hopefully he'll turn himself around, but I think what's appropriate here, because this is a state jail and the facts of the original charges, that we give him a sentence of a year's state jail time.
All right, anything you want to say? How much do you have? How much money do you have to pay the victim today? And do you have some money squirreled away somewhere?
Yeah, I don't know how much on there on my phone. I got money on my phone.
I'm sorry.
I got money on my phone. I don't know.
What does that mean?
Like on the app. Apple Pay.
How much is that?
I don't know how much on there.
Like, about how much?
Like $200 or $300 on there.
Okay, here's what I'm going to do. I'm going to find, if there's nothing further, I'm going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater, as allegation 2 has been proven true, that the defendant has failed to provide verification of entering and successful completing moral recognition therapy again. And this is after we had taken this up a few years ago and found it true. The defendant has nonetheless had an opportunity to do it and has not essentially put in any effort in moral recognition therapy over the course of his term of probation, which is now 9.5 years, over 9.5 years. All right, so this motion to revoke unadjudicated probation is hereby granted. Earlier in this case, the defendant pleaded guilty voluntarily. He was mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that hearing to find you guilty beyond a reasonable doubt. We instead placed you on deferred or unadjudicated probation. That deferred or unadjudicated probation is hereby revoked. I now find you guilty beyond a reasonable doubt of this underlying state jail felony of burglary of a building. You are hereby sentenced to confinement in the state jail for a term of 2 years. And you have 162 days credit, which means you have a lot of time in jail, in state jail. But what I'm going to do is place you on regular probation. And that will be, okay, what am I able to do here? How much can I place him on regular probation for?
Should be 5 years.
Can I?
Leave.
I thought you could only do no more than 10 years, right?
You can't do more than 10 years.
Sir?
You can't do more than 10 years.
Even when it's revoked and.
It's total 10 years. I don't know.
And he's been on probation
Since November 2017, let me check that date, Judge. Correct, November 6th, 2017. So whatever the math turns out there.
Anytime, I guess.
Here's what we're going to do is we're going to place him on this probation for the balance of the time that would make the anniversary of 10 years from the time he was placed on probation.
It's approximately 16 months, Judge. We've got 4 months before he hits his anniversary and then an additional year.
You're past 10.
Oh, forgive me. What's your?
So what we'll do is place him on that for that period of time from today to November 6, 2027. And we're going to review this in 3 months. And if you hadn't come up with substantial amount of restitution here, we'll be back on a revocation, and then it could result in 2 years confinement. So it's up to you to try to get these people paid back that you're responsible for. Do you understand? So everybody understands where we are on this. You got responsibilities to yourself and at home. Listen, live up to them, sir.
Yes, sir.
That's here's this one. Do I have a plea ready? Yes. There was somebody working on something, right?
Plea ready.
What about the other gentleman? What are we doing on Mr. Marino? We reset Marina?
It's placed on the trial document.
It's placed on the trial document. Theo, where's Ted John?
He's in the back talking to his client.
Bruce, what are you going to do?
They're both police, Judge.
Okay. On Kendall and Xavier?
Yeah.
What else do you have, John?
We had that one where the hearing with the witnesses on Bronson. Was probably the last thing we did.
Hey, that last one, Stan, where's something is in there?
No, that's not just. I can't believe that can use some wash over there and stuff. That's just for confinement.
Okay, great.
Actually, super
That's what I need.
Thank you.
Who's up? Anybody ready?
There's a Natasha Seals for review if you want to handle that. While we're waiting, Judge. I've got two pleas with Bruce and a hearing with Joe.
Are you signed up, Bruce?
Yeah.
Okay, you come on up. Let's go. It's Kendall Andrews and Xavier Finn. Kendall Andrews? Yep, thanks.
Let me get fingerprint, Mr. Andrews.
There's a motion to revoke and a new case, is that right?
That's right. 6 ends running C6.
Up in here, Mr. Andrews. Please raise your right hand. You swear or affirm to tell the truth, all the truth, and nothing but self you got. Okay. Think it's your right thumb print. Place it flat with your elbows. Pick it up one more time. Place it flat here. You just stand up.
Kendall Andrews?
Sir. Yeah.
We have two cases. Cause number 24CR 559. That's a motion to revoke unadjudicated probation, and a new case 25CR 1332. Second degree felony of indecency with a child by sexual contact, and the defendant was on probation in the earlier case 559 for the third degree felony of, looks like
injury
to a child. Does the defendant waive formal readings of the motion to revoke unadjudicated probation in 559 and the indictment in 1332? Can we proceed in Sunday?
It is right.
Check them up numerically. And 24CR 559. There's a motion to revoke unadjudicated probation. And in each of these cases, the defendant waives formal readings of the charging instruments, and we can proceed in summary.
Yes, Your Honor.
Mr. Andrews, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? So lower your hand. You are Kendall DeWan Andrews. Yeah. In this motion to revoke unadjudicated probation 24CR 559, in summary, this alleges that on March 27th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on deferred or unadjudicated probation for 10 years for the offense of injury to a child younger than 15 years of age. Do you understand? Is all of that true and correct, sir?
Yes, sir.
What are we pleading truth?
Yeah.
One is The indecency, which is represented by the new indictment 25 CR 1332.
Yes, sir.
Allegation 1 states you committed the offense of indecency with a child by sexual contact on or about May 9th, 2025 in Jefferson County, Texas, which is a violation of condition 1 of your deferred or unadjudicated probation order, which states that you shall not commit any offense against the laws of Texas, the state, or any other state or of the United States. Is allegation 1 true and correct?
Yes, sir.
Are you pleading true and correct voluntarily and because it is true, as it is alleged? Correct? It's true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that's enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can now be revoked. You can be found guilty and sentenced up to the full range of punishment for this 3rd-degree felony, which is no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir.
There is an agreement that's been reached in this case where you would be pleading true, found guilty, sentenced to 10 years in prison. This would run concurrently with the sentence that is going to be assessed and a plea of guilty you're going to be entering into in the next case, this 2nd-degree felony of indecency with a child, 25 CR 1332. Is all of that true and correct?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Yeah. Hold on, everybody. I'm going to try to erase something off the pad and using this stylus that anything can happen when the stylus touches this pad.
Glad to hear it's not just on me.
All right, I am going to follow this agreement. Anything to add before I make findings here on this case?
No.
Anything you want to say, Mr. Andrews?
No, sir.
If not, I'm going to find in this motion to revoke unadjudicated probation 24 CR 1559 that you were placed on probation earlier in this case on March 27th, 2024 in this court. I find you are pleading true to allegation number 1 of this motion to revoke probation, committing the offense of indecency with a child.
Yes, sir.
As we have placed into the record. That is supported by your voluntarily and knowingly made plea of true to that violation, admitting it. That is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. This motion is granted and your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty to this 3rd-degree felony of injury to a child, causing bodily injury to a child younger than 15 years of age. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at that hearing initially to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the 3rd-degree felony of injury to a child. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. Do you understand what has happened in this case, sir?
Yes, sir.
We now go to 25 CR 1332. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in sum? Yes, sir. In summary, this indictment handed up on September of 2025 alleges that on or about May 9th, 2025 in Jefferson County, Texas, you committed the second-degree felony of indecency with a child, bisexual conduct, namely touching the genitals of the child, a person younger than 17 years of age. Do you understand what you are charged with here?
Yes, sir.
I believe the child was 10 years of age at the time of this event. Is that correct, everyone? That's what this alleges in the probable cause affidavit.
That would probably be accurate, Judge.
If convicted of this crime, this is a second-degree felony, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed to not to exceed $10,000. Do you understand?
Yes, sir.
It is accurate, Judge.
An agreement has been reached where you would be pleading guilty, found guilty, sentenced to 10 years in prison to run concurrently with the preceding case that you were placed on probation for, was revoked and sentenced to 10 years a few moments ago. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Sir.
Have you pleaded this second-degree felony of indecency to a child with contact by contact? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1 in this case. Did you sign that document, understand it, discuss it with your attorney?
Yes,
Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection if admitted. This states, among other things, you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. It's made a part of the record for all purposes. Pre-sentence report this way.
We would, veteran.
I'm going to follow this agreement. Anything else to add by any party?
No, yeah.
Not, I'm going to find that Kendall Dewan Andrews, Dewan Andrew, am I pronouncing your middle name? Dewan Andrews, you are pleading guilty to the second-degree felony of indecency with a child. Voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
I now find you guilty beyond a reasonable doubt of the second-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice prison to serve a term of 10 years. And this sentence shall run concurrently with the preceding cause number 24 CR 559, the probation of the injury to a child for which you were just a few moments ago revoked off of your probation, found guilty, and sentenced to 10 years. These will run concurrently. Also, this indecency with a child is an offense under the state of Texas laws, which require you to register as a sex offender under the sex offender registration program in Chapter 62 of the Texas Code of Criminal Procedure. Do you understand you have responsibilities to comply with that part of the law? Failing to do so is a criminal offense that may result in prosecution. If you move to another state that has similar reporting requirements for sex offenders, you must register in that state. Failing to register would result with you being charged with a criminal offense. I'm looking at a document that looks as though you've signed this and your attorney has acknowledged that he's discussed this with you. Is all of that true and correct?
Yes, sir.
All right. This is made a part of the record as well. It's called Sex Offender Registration Admonishments. And you have continuing duties under this law to perform responsible. Do you understand what has happened today, sir?
Yes, sir.
God bless you. Just 1 second, please. You are 22 years of age now, correct, sir? Is that right?
Yes, sir.
Okay. One thing that this court is just going to add as, I guess, an additional footnote on this. Each of these children were 10 years of age at the time they were assaulted, sexually assaulted by the defendant. These were your children too, correct? No, they were, you foster the child's mother you were married to or had a relationship with?
No, sir.
Okay. What was the relationship these children were to you?
Cousins.
I'm sorry?
Cousins.
They were part of your family, though. But they were family members, right? Yes. They weren't just strangers. They were family members.
Yes, sir.
Okay. And you are 22 years of age, correct?
Yes, sir.
You were on probation for the injury to a child, which was a sexual assault of causing bodily injury by touching the anus of the little child. And I read the probable cause, and it's you were you invaded the anus of the innocent child with your finger. And then here, this indecency with the child is touching the genitals of the child. And these are both 10-year-old. These were both 10-year-old children. There's probably no worse of a crime than the harming of a child and the sexual exploitation of a child. Not just one, you got two here. And this is all too often happening of cases in this courtroom. I don't know what the problem is, but it will be dealt with severely. The state is very vigorous in prosecuting this. There's no one that has any sympathy with someone who harms a child. No one. The children really are almost defenseless when they're 10 years of age, or an adult took on them, come along and assault them. And from what we all know, it's not like they can forget about it. A 10-year-old can remember. I remember when I was far younger than 10 years old of important events that affected us emotionally. So this child isn't just victimized once. I'm sure she will relive this horror maybe most of her life. So you will be victimizing her maybe all the rest of her life. Can you think anything worse than that? No. Well, it will be dealt with severely. The law states it shall. The state's pretty vigorous, and this court will continue to be very aggressive and just. But justice when you harm a child is severely assessed. Do you understand?
Sure.
That is all. How do you give back the innocence of a child? You can't do it. And I mean, I'm saying it almost every day. It's maybe the most blessed thing that our Creator's ever given us is a child's innocence. And it's up for us responsible people to ensure that they are protected. And too often in this room, we have people who couldn't care less about harming a child, but they'll be continuing to be dealt with. What do you have next?
We have Xavier King.
Okay, Xavier Kane.
Judge, please sign this probation orders real quick for that previous defendant. Thank you.
Xavier Kane.
So I'm sending misdemeanor alert. Ms. Smith's. Very bad. I was going to do the same thing on his, but he had already taken time served.
Yeah. Got a lot of fixes in this today. 6/26/26. That's today's day.
Thank you.
Xavier Kane is next. You're Xavier Kane? You were here with Mr. Smith, your attorney, and the state's attorney. Let's just take file. 17-27488 is called. Xavier Kane, present with Mr. Smith, his attorney, and the state's attorney Does the defendant waive a formal reading of this second amended motion to revoke probation filed on May 1st of 2026. Can we proceed in summary?
Yes, Your Honor, we're proceeding only on count 7.
Raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Swear.
Lower your hand. What are we going to do for you here?
We're proceeding only on count 7.
7, which is committing the offense of failing to identify as a fugitive on April 19th, 2026. Is that it?
Yes, sir.
Correct.
Okay. In summary, sir, this second amended motion to revoke probation filed again on May 1st, 2026 alleges that on April 3rd of 2023 in this criminal district court of Jefferson County, Texas, you were sentenced to 10 years in prison, and that was suspended for 9 years probation for the third-degree felony of evading arrest or detention with a motor vehicle. Is all of that true and correct?
Sure.
Allegation number 7, the second amended portion of this second amended motion to revoke probation alleges that you committed the offense of failing to identify as a fugitive with intent to give false information on or about April 19th, 2026 in Jefferson County, Texas, which is a violation of condition 1 of your probation order which states you shall not commit any offense against the laws of this state or any other state or of the United States. Do you understand what you're charged with here, sir? Is that allegation true and correct as it is alleged?
True.
Are you pleading true and correct that voluntarily and because it is true? Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can be revoked and you can be sentenced up to the full range of punishment. In this case, it's no less than 2 nor more than 10 years confinement in prison. Knowing all of that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement's been reached where your probation would be revoked and you would be sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
Yes. Okay, you have to speak out. So
Yes, sir.
Okay. If I follow that agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Hold on. I show you what's marked as State's Exhibit 1 at the bottom there. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states if I follow this agreement, I'm going to do this. You have no right of appeal. You understand? State's Exhibit 1, part of the record for all purposes. Pre-sentence report is hereby waived.
It is.
I will follow this agreement, sir. I will find that you, Mr. Kane, has pleaded true voluntarily, knowingly, intelligently to allegation number 7 of this second amended motion to revoke probation in this cause number 17-27488. That is enough, a knowing and voluntarily made plea of true to one or more violations. That's enough to grant a motion to revoke probation. Your probation can be revoked. I hereby revoke your probation as I find you have voluntarily, knowingly, intelligently admitted to violating allegation 7, which is committing the offense of failing to identify as a fugitive with intent to give false information on or about April 19th, 2026 in Jefferson County, Texas. And that is a violation of condition 1 of your probation order. Was that case formally filed?
It is.
It's in a misdemeanor report?
It is.
What's the status of that?
I'm going to dismiss it as a portion of this agreement, Judge.
Okay, you have a copy of it?
I have a copy of the PC, Your Honor. I can get you.
I'm talking about the information.
I don't have that information. I can print it, but this is the PC that goes along with it, Your Honor. Would you like that document, Judge?
3802. I think it's 3802, right? Is that what you're showing on the probable cause?
Yes, sir. 3802.
Sir,
Friend D2.
I just want to verify on the record under section 38.02 of the Texas Penal Code called failure to identify. And I think this is what we're talking about. What caused you to violate the probation and result in this motion to revoke probation that we've just had. A person commits an offense if he intentionally refuses to give his name, residence, address, or date of birth to a peace officer who has lawfully arrested the person and requested the information. Is that what happened in this case? Okay. And you're pleading true to those elements that you intentionally refused to either give your name, residence, address, or date of birth to a peace officer who had lawfully arrested you and requested that information. So that, again, results in information that adds to this finding that you committed that offense of failing to identify as a fugitive with intent to give false information on or about April 19th, 2026 in violation of conviction 1 of your probation order. Your probation is thus hereby revoked, and you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. I don't know how much credit you have so far, but you will be given credit for all time you have served in accordance with this case toward your punishment and judgment. Do you understand?
So even when I first started probation?
Shoot, I don't. Any time from the time you not only were placed on probation, from the time you were arrested for the offense, it goes back to the beginning. You get. This is the ultimate end of it. And when you're sentenced, you're given credit for all time you have served in accordance with the case, even before you were placed on probation. I don't know how long you were in custody before all of that happened. But the clerks have it all in the data. And if there's a problem, you tell you probably know, but you tell your attorney and he can do something about it. But strangely enough, out of the thousands and thousands we do, we rarely have a problem. Rarely, because it's all in the computer done. And when they put it in the computer, they're doing it at the time it's happening. So generally it's accurate. Okay, good luck. Yes, sir. Bruce, what else? Is that it? Anything else, Bruce? No. Thanks. Hey, John. What are you doing in Chaston, Bryson?
That's gonna be hearing, Your Honor.
Okay, we have a hearing on that? Yeah. Okay, what else do we have on a plea? Come on up. This is on Mario Jobert?
Yes, sir.
Okay.
Jobert?
He's in the back?
Yes, sir.
We need him out, all right? Okay. Mario. Does he have a brother?
Brother Mario.
Marlo, why do you keep calling this baby? What did you do with that discovery sheet? You got that already? Okay. Here's the rest that goes with it.
Well,
I need to know if you're please.
It's a moment.
Should be.
Sir, please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, self you got?
Yes.
Okay, can you put your right hand friend? Place it right there in the box.
We still have a hearing on Natasha Seals, right?
That's just a review as to.
How's she doing?
So she's at a point where we're checking how she's doing on restitution.
Okay.
And I don't know that answer.
And then I just have Joseph Ledet or Ledet.
That's the same thing with him as well.
Those are reviews?
Yes, sir.
All right. You are Mr. Jobert Marlowe?
Yes, sir.
And you were here with your attorney?
Yes, sir.
Mr. Johnson, the state's attorney. I think what we have here is a motion to revoke probation in the older case 18-29833 and a 26 CR 392, a new case indicted on March 18th, operating a motor vehicle in a public place while intoxicated, third-degree felony because of prior DWI convictions. The defendant was on probation for DWI, and it looks like this new indictment is represented as allegation 1.
Yes, sir.
In the motion to revoke probation, among other things. He's got 6 violations alleged, but we'll probably be working just off 1.
Well, yes, sir. But
That's all that's necessary.
Let's say this in terms of
what are we doing?
Probation fees, they're paid up. I know it doesn't make a difference, but I want to let that know.
Okay.
Let you know.
Well, that's not an issue, is it, with the state?
No, sir.
Okay. So is that what we're going to do? He's going to enter a plea in this motion to revoke probation on the allegation which is represented in the new indictment, and he's going to be pleading guilty to the new indictment and going to run everything concurrent?
Yes, sir.
What's our plan?
4 years TDC.
4 years TDC in both cases?
Yes, sir.
To run concurrently, right?
Yes, sir.
All right, that's your understanding, sir?
Yes, sir.
All right. So what are you going to do when you get out about this happening again? What are we going to do to prevent it?
I'll get more help, counseling, and
Are you an alcoholic?
I'm an alcoholic.
Are you?
But due to stress, there was a lot of stress was going on in my life at that time. So, son, and stuff.
There's one thing.
Yeah, I feel like I'm
not going to talk to you like your dad or something, but welcome to planet Earth.
Yeah, I'm here.
We all have stress.
Yes.
All of us, every one of us.
Yes, sir.
Sit here and see how relaxing it is. It's like a clenched fist, but that's what we do. We manage it and deal with it and move forward as best we can.
Yes, sir.
But you got to recognize when you're in stress, you've got two ways to go: the right way or the wrong way. And the wrong way has responsibilities that you pay for.
Yeah, that's why I'm here. I chose the wrong way.
Well, fix it.
Yeah, I'm gonna fix it.
Okay, good.
I'm gonna fix it.
And you can always start today. All right, let's go. 18-29833, a motion to revoke probation. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
Mr. Hubert, raise your right hand. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion states, and this was filed on February 4th of this year, it states that in this criminal district court of Jefferson County, Texas, on June 17th, 2019, you were sentenced to 10 years in prison, and that was suspended. You were placed on regular probation for the third-degree felony of operating a motor vehicle in a public place while intoxicated. We call that driving while intoxicated, but we know that the elements of the crime don't include the word driving. It's operating a motor vehicle while intoxicated. Is all of that true and correct?
Yes.
And allegation number 1 is represented by this indictment 26 CR 392. In summary, allegation 1 states that you committed the offense of driving while intoxicated, third, or operating a motor vehicle while intoxicated, actually, but it's the crime is entitled driving while intoxicated, a third-degree felony, because you had 2 or more prior DWI convictions at the time, and you committed this offense on or about December 11th of last year, 2025, in Jefferson County, Texas. That is a violation of condition 1 of your probation order. And condition 1 states you shall commit no offense against the laws of this state or any of the state or the United States, which this is a violation of Texas law. Is this allegation true and correct as it is alleged in this motion to revoke probation?
Yes, sir.
Are you pleading true and correct to this voluntarily and because it is true as it is alleged?
Yes.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can now be revoked, and you can be sentenced up to the full range of punishment, which is up to 10 years in prison. Knowing that, do you insist on pleading true today?
Yes.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. God bless you. And now an agreement has been reached between the parties. We only needed to really do this agreement portion. Since it's a motion to revoke probation, an agreement's been reached where you would I'm going to replace You're for with the Arabic for?
Yes, sir.
That we're used to. You know what happens is you're writing fast, and on this pad, it's you think you got problems. You know, I'm left-handed, so I put my hand on this, and look what I've done. Look what I do. I have to put this thing because the way I write as left-handers, if I didn't put this thing on top of it, it smudges it and it begins to write things. Well, I know what I feel your pain.
I have trouble writing period, Judge.
I've known you for a long time, Tim. I know that. In fact, the whole town knows that. We all know that. The whole community of law, we know. But we love you. That's what's so great about it.
I had trouble in law school.
Let me tell you, I miss your dad.
Yes, sir. Yes, sir.
Hardly a time goes by.
Yeah. Judge, one day I'm bring his notes from college up here and let you take a look at them.
Yeah, I like that.
Yeah. They were meticulous.
I'm not surprised.
But
he was fabulous guy.
But the bad thing about it, he was meticulous, but he was always late. So he called secretaries up.
Well, I think he was probably busy on other things all the time.
Well,
that's the way I understood it. He wasn't late because he wasn't fashionable that way. I think it was because he got wrapped up in things, and then he go, "Oh, look at the time." Of course, he had that buddy of his that got him into some trouble. Elmo Willie, those guys.
Well, his son's doing really well.
Yeah, that is right.
You notice that?
Yeah, yeah. But both of them were premier lawyers and very smart people. Very smart. Both of them were very smart people.
Yeah,
I was a young lawyer, and they were very kind to me as a young lawyer.
We got on the Wayback Machine. I remember being on your dad's television show.
Yeah, I was out.
I still have my cowboy boots on.
Oh, did you?
You know, at the end of his television show, he would say, "Stump your boots and clap your hands."
Well, that was everybody watched that show.
Yeah.
Anything can happen on live television, by the way, in those days with kids. I'm surprised that they didn't lose their license sometimes, because things would be pop out of kids' mouths, and it was live television, and it wasn't. Some of it was not appropriate, but people watched it because it was like a box of chocolates. You didn't know what you were about to get.
Yeah, everybody watched that show.
It was something else. Anyway, back to this 4 years imprisonment, and this is going to run concurrently with this other case. If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
We'll show you what's marked as State's Exhibit 1. Did you sign that, understand it, discuss it with your attorney? Are the contents true and correct?
Yes, I did.
State's Exhibit 1 is tendered into evidence?
Yes, sir.
Without objection. Ted?
Yes, sir.
And it's made a part of the record. Among other things, State's Exhibit 1 states you are giving up all rights of appeal if I follow this agreement, which I am going to do.
Yes, sir.
If nothing further, I'm going to find on this case there is sufficient evidence supporting this motion to revoke probation to grant it. My preponderance of the evidence or greater. Allegation 1 is proven true, as the defendant is voluntarily, knowingly, intelligently admitted to committing the offense of operating a motor vehicle while intoxicated on or about December 11th. 2025 in Jefferson County, Texas, in violation of condition 1 of his probation order. Commit no crimes is that condition. Thus, this motion is granted. The defendant's probation is hereby revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened in this case, sir?
Yes, sir.
And does the defendant waive a formal revision of the indictment and the arraignment in 26 CR 392? Can we proceed in summary in this case?
Yes.
In summary, this indictment alleges in paragraph 1 that on or about December 11th, 2025 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while intoxicated. Do you understand what you're charged with there, sir?
Yes, sir.
Paragraph 2, though, goes on to allege that you have 2 prior convictions in cause number 12-13837 for a DWI, operating a motor vehicle while intoxicated, in this criminal district court of Jefferson County, Texas. And on September 11th, 2014, 1 month later, you were convicted out of County Court of Law number 3 in Jefferson County, Texas, for the offense of operating a motor vehicle while intoxicated in cause number 303751. Are those allegations true and correct that you have 2 prior DWI convictions operating motor vehicles in public places in 2014?
Yes, sir.
Are you pleading true to that allegation as alleged here in this indictment?
Yes, sir.
And are you pleading true and correct of that voluntarily and because it is true as it is alleged in these 2 allegations?
Yes, sir.
And do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that's enough?
Yes.
To support paragraph 2 of this indictment, which enhances this operating a motor vehicle in a public place from what would be a misdemeanor to a felony offense.
Yes, sir.
Understanding that, do you insist on pleading true to allegation number 2?
Yes, sir.
Of the 2 prior convictions of DWIs?
Yes.
And allegation 1, is that allegation true and correct that you committed an offense of operating a motor vehicle in a public place while intoxicated on or about December 11th, 2025 in Jefferson County, Texas, after you have been convicted twice of 2 DWIs?
Yes, sir.
Paragraphs 1 and 2 constitute a 3rd-degree felony. You face no less than no more than 10 years confined in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached. In your case, you would be pleading guilty here to this felony, sentenced to 4 years confined in prison to run concurrently with the preceding case. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal. You understand?
Yes, sir.
So you hear what's marked as States Exhibit 1. Did you sign that document? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection. It's admitted.
Yes, sir.
Among other things, this states you are mentally competent to enter your guilty plea. It's a freely and voluntarily made thing. You are doing this based upon discussions with your attorney. You were guilty of this offense and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1, for the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I will follow this agreement if nothing further. I'm going to find, Mr. Gilbert, you are pleading guilty in paragraph 1 and true to paragraph 2, which is admitting to operating a motor vehicle in a public place while intoxicated after you have 2 prior convictions of operating motor vehicles in public places while intoxicated out of Texas courts. That constitutes a 3rd-degree felony. You are mentally competent to do so. You understand and appreciate the consequences of pleading pleading guilty and true, respectively, to paragraphs 1 and 2 constituting this 3rd-degree felony. I now find you guilty beyond a reasonable doubt of this offense. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. And these sentences of these 2 cases this morning will run concurrently with each other. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add here?
No, nothing, sir.
Then we are done. Thank you.
Thank you, Your Honor.
You do me the honor. All right, that is here. What's next? I have Joseph Ledette, and I have 2 other cases, Chadston Brightson and Chadston.